And this includes the delivery charge. The delivery boy who delivers it, his charge as well as the cost. Now, if I may mention the review application of Justice Tandon sitting with Justice Hiranmoy Bhattacharya. Well,
long back.
Yes, Milord. This was the last order passed, Milord. Any day convenient to Milord, your lordships, if your lordships may kindly reassemble, Milord. This was the last order passed. Well,
My lord, this is
all
for
order 41. Give all order 41.
My lord, this is for application, my lord.
We are taking up. All order 41 give. Hey, niya now aru ache ekta. Give all applications. Review, contempt, whatever. Please. Whatever, please give applications.
Not listed, but
Yes, give the, no need to mention, give the applications.
Yes, application.
Give applications. Give. Yes. A Firod diye dao. Firod diye dao. Which one is yours? We said we have accepted. You are mentioning what more?
Your Lordship,
Yes.
I am praying for an upgradation for assigned hearing matter, Your Lordship. Item number 200.
We will fix a date for the hearing. Don't worry. We'll just take up those matters.
Yes, Your Lordship, but the petitioner is suffering. That's why I am mentioning.
No. Every litigant suffers. No doubt about it. When the matters are pending before the court, we'll definitely give precedence. Don't worry. We'll assign
Deeply
one
obliged,
day
Your Lordship.
for hearing. Don't.
Yes, assigned hearing matter, Your Lordship.
Yes. We'll fix a date for hearing. Don't worry.
Deeply obliged, Your Lordship.
Number 155, Lord of the Lord. Appearing under the head hearing.
Have you seen the bench was absolutely irregular? And I don't know. That's why just wait for it.
That is the reason why I'm mentioning.
We are taking up all those matters, sir. Hearing, sir, when you come, we have fixed a date for hearing. We could not get one matter ready for hearing. 3 days were absolutely wasted when we took up. No, this is not a way. We are calling all the matters. Nobody was interested. We got frustrated that bar is saying I am ready. Whenever the matter is called, says that he is engaged somewhere else. He has not come to the court. Some very genuine ground. We can't say no. Every day we have experienced. My brother will share with me on at least 3 occasions this happened. Just my brother who sat into 27 jurisdiction whole day, he could not get a matter. And you are saying hearing matter.
The problem is
Simply because Mr. Mukherjee has a persuasive appearance, he is appearing, that does not mean. Just wait. We'll take up all the matters.
Item number 296, Milord.
And ensure at least 7 matters. The lawyers must be ready and no adjournment. Will not grant adjournment. We are ready to dispose of.
Milord, may I have a lordship's leave to mention item number 296 for upgradation? Milord, this is an application for stay in connection with the first appeal.
We have been taking up application 2 days.
New application which has come up in the list.
Anyhow, it will be. We will be assigning 1 day for application.
16th is the date fixed for delivery of possession with police help.
It's a long way. This week we can fix 1 day for application.
16th is the date fixed of March.
16 is long way.
Of March. End of.
Long way. Today is 4th.
Another week is there.
So you just wait for this.
Kindly, my Lord Justice Prasad, my Lord, I am mentioning Tandon, my Lord, this is regarding review. My Lord, Justice sitting with my Lord Sampad Dattapal.
Lord, with your lordship's kind leave, Lord, I'm mentioning FAT 33 of 2024 for listing before my lord. Lord, listing of the appeal along with an application for stay.
2024 appeal.
2024.
Just wait, sir. There are 2,000 appeals of the year 2000 pending.
Lord, the only urgency is, Lord, I am being proceeded against in execution, Lord. That
An
is
application, it has to be heard first.
Yes, Lord. Yes, Lord.
Give that application.
I'm grateful. I'm grateful.
Return. Why you are mentioning? When we said all applications, please give,
Yes.
then why you are mentioning?
My lord.
Of which year, madam?
100 of 2020.
It's a very new one. New one, just wait.
Correction of my lord's.
Yes, sir. Now the same scenario last time we recorded.
We have given the notice to Advocate General.
Recorded. There's no. Can you give another chance? You have given a notice to the.
Yes.
He was here, learned Advocate General. He came for mentioning and then you should have reminded him
I was not seen him.
to mention what matter. Yes, what is the matter about? We can't wait eternally all the time. Have you
Not-
given a
yes.
notice?
Well, back.
Hmm? Yes.
The vacancy for fair price shop is under challenge in the
Fair price shop.
fair price shop.
Fair price shop.
My lord, MR dealer is under challenge in the present writ petition. Will you kindly turn up to the vacancy notice at page 46.
Now, first, let us see what is the
Order of the learned single judge. Prayer for interim order has been rejected. Against that, we came before Lordship. Your Lordship
Yes.
obtained an undertaking from the Honorable Learned Advocate General that they will not proceed. And they have not proceeded also.
order of 3rd December 2020
My lord.
is the subject matter of
My lord.
challenge. Where is a order of July 21, 2014?
That yes, page, my lord. Page 59. But out of two conditions, one condition has already
So
been.
what is the effect of this interim order? You were really trying to get the advantage of the interim order passed in this proceeding. But I do not find there is any reasons which has been assigned.
So far, the order,
The judgment of P. Mahindra was considered. That was on a absolutely.
no, actually, I am not
context.
banking this judgment that I have placed before the learned single judge. But my case is that, my lord, so far, if you will kindly come to the vacancy notice, page 46, two conditions. Page 46, my lord.
Yes.
Is a vacancy for appointment of fair shop dealer.
No, I understand that he must be a resident. In case of an individual, resident. In case of a group of individuals, no residence.
First,
Or a corporation.
First. The next is, my lord, clause number 6. Working capital
5 lakhs rupees preceding 1 year.
Then, my lord, kindly 8.
That is embargo, he should not be employed somewhere else.
Only in case of individual.
Correct.
If it is a partnership firm, he may be a panchayat member, he may be a bank manager also. Group of individuals.
Yes.
Kindly see the applicant.
No, I understand. I understand what you want to say.
Now, subsequently, what happened, my lord, I have handed over on last occasion. So far, this financial capability is concerned, that has been reduced, and ultimately.
That was in case of another one. It is a case of a.
No. That is MR distributor is there, but so far dealer is concerned, that has also been reduced. Now, today, condition is that 50,000 only on the data application. I have handed over on last occasion, my lord.
Now the question is that they have reduced, but that can it go retrospective?
No, that has been categorically stated. So far, the fresh vacancy is concerned.
Correct. So if cannot, then this you can't take advantage of that.
I'm not taking, but I'm saying that whatever ground I have taken, that has been ultimately accepted by the state. And so far, the MR distributors.
All the policy decision. If the government want that, they should, because they are the competent authorities to decide the eligibility criteria. There is nothing in the act which prohibits any kind of the impositions to be
But
made.
the condition must be a practical one.
Reasonable. I understand. It should be a reasonable one.
But what happens, so far the MR distributors is concerned, the condition was 50 lakh on the date of application and preceding 1 year. Number of cases has been filed. Ultimately, if you have to kindly take up page, my lord, 50 of my writ petition, stay application. Just first paragraph I reading before lordship, page 50. With reference to the caption subject, the undersigned is hereby directed to state that the approval is hereby accorded
That
But
is the total number of 21 MR
yes,
distributors.
kindly see, my lord, 9 January 2019.
Correct.
Now, your lordship, kindly in terms of that approval, vacancies have been notified that I have also annexed. Then kindly turn up to page, my lord, 56. The first paragraph, page 56, relying on that approval, 9 January 2019, fourth line, first paragraph.
Yes.
Kindly turn up to third paragraph. And whereas besides above reasons, the department has been made to contest several court cases in the Honorable High Court at Calcutta against the aforesaid vacancies.
50 lakhs 1 year, generally tax still pending in different stages.
Then the ground of applicability of the clauses, particularly relating to the restrictive clause of financial solvency of rupees 50 lakhs for last 1 year from the date of application and January, member of the so-and-so. And whereas considering the above facts and circumstances, the state government
They have cancelled the notification.
entire notification, so far the MR distributor is concerned.
Correct.
So my specific submission before your lordship, government definitely can take a policy decision.
Correct.
But that policy decision must not be discriminatory. That should be reasonable one. That should not be impractical one also. The specific case I have made out, you understood that these 5 lakhs for the last 1 year, because I have the 5 lakh rupees. But I cannot keep it for last 1 year. I don't know when the vacancy will be notified and when it will be concluded. I'm an unemployed youth. You are saying that you must be unemployed youth. This is impractical, unreasonable. No logic behind this. And if I am a partner of a partnership firm, I can apply in all over West Bengal. If I am a partner of a partnership firm, I can be a bank manager even. I can be a panchayat member also. Totally impractical. It's unreasonable. No logic behind this. So
the concept of the partnership is that actually the partnership
firm is applying.
firm is
That's true. But
compendium name of two.
I understood, my lord. But kindly consider two individuals.
Two or more individuals.
I know, my lord. Two formed a partnership.
So they would still be regarded as an.
So what is the logic behind it? If I be an individual, I must be in the local area. If I formed a partnership firm with my brother, I can apply on in all over West Bengal.
Talk about then the concept of partnership has to be understood. The concept of partnership is that these two or more
separate identity.
No, not separate. Two and more persons, they have joined together and they wanted to start the business in a compendium name of a particular thing. One can be known. 7 persons will be known as this compendium name. That's all. Nothing more than that. But it's still they are responsible for every loss or the profits that they earn during those. So I do not know if the individuals are there, then in a partnership firm, you are giving an example that does not appear to be an apt one in this case. Does not appear to be an apt in this case. Partnership. I can understand the
another reference. A partnership firm keeping 50,000 money in a bank account can apply against 10 vacancies, showing that particular account. I cannot. Even 7 members.
No.
Yes, my lord. Only bank account, one account, suffice for all vacancies. It says 50,000 on the date of application. It does not say for each vacancy, you have to show it.
So far as the partnership firm is concerned, I'm telling you, it is a partnership firm which carries on a business at a particular place. They have I would say the business establishment within a particular jurisdiction, geographical. That's only out of way, which I am thinking about. If that being the position, I am still in doubt whether he can apply multiple. He can make multiple applications.
Condition says
it will be considered that where he has the working place, where the partnership office or the firm.
It's happening, my lord. Practically, it is happening.
That would be regarded as the place.
I have moved one case before your lordship, Mr. Kollan Mandha, the other side. I have submitted before your lordship. One company, 6 distributorship, showing one account. Same thing. I have shown to your lordship.
No,
in that case, even my lord, kindly consider if I jointly apply,
Where is the release claimed in the writ petition? Where is your writ petition?
Page, my lord, I have annexed the entire petition.
Please, to us.
It starts from page, my lord,
No, release where you have claimed.
39. Cancellation of vacancy, page 39 of my stay application. This is the prayer of the writ petition. Cancellation of vacancy and declaration of fresh vacancy. Prayer B, after removing the anomalies.
Where you have pleaded these grounds in pursuit of this cancellation. Where you have said that this is absolutely, or you have paragraph 25.
Paragraph 25.
Yes, 27 also.
Paragraph 26, 27, 28, 23 also was the transparency. Well, paragraph 21, 22, you'll also kindly read also.
Where is the other?
Paragraph 21.
Which one? Need visual care.
It starts from paragraph 19.
Main problem क्या है? Individuals के case में first is a criteria. He must be a resident, permanent resident. First,
These are all paragraphs of my writ petition.
says 5 lakhs preceding one. And then 8. Individual. But why he says that it's not a complete where the partners distracted and the
Can put that
this modification or vacancy is the certificate of the vacancies. Several so they are really coming. Is there any rules relating to what are the fair price distributorship or fair price
West Bengal
distribution?
Public Distribution System Maintenance and Control Order.
Yes, where it says that how they will run, there is any criteria?
Which is the relevant control order regarding the conduct of
West
business
Bengal
of the
Public
fair price
Distribution
shop?
System Maintenance and Control Order 2013. We are in that.
Surprise. It's a good one. So it's what I do.
On one hand, you are saying you must be a
So they gave an undertaking not to proceed. So this is already there. In this case, no one is- That is the that cannot be. Yes. The children case did not pass any. Yeah, he's raising it. So they have given a undertaking to us in this procedure.
I mean, one is saying that I should be a unemployed youth. But how can I show it in my income tax return? Rupees 5 lakhs.
Where is the requirement of being an unemployed youth?
My lord,
Where is that requirement that the applicant has to be unemployed?
my lord, I'm showing you. Condition number 8.
No, not employed in any government, semi-government organization. Not that you have to be unemployed. That's not a requirement. That it is not expected that you will not have any income.
My lord,
You
the
should not be
document must be enclosed. Clause number 6. Document must be enclosed. Just before letter that.
No, proof of unemployment by means of self-declaration or employment bank card.
So these are there, my lord. What is there? That is.
You have to
But
be unemployed.
at the same time, kindly consider, unless I'm unemployed, I should not apply for a distributorship or dealership business.
Embargo. That is
No
what
embargo.
my brother is asking. Where is an absolute embargo that unless you are an unemployed youth, you can't apply?
No.
That gives a very.
My case, specific case is that, my case, that I am an unemployed youth. You are saying
maybe.
rupees 5 lakh for last 1 year.
No, if
Why?
you are-
How? But nowadays, a
Sir, you
person
are
will
right.
keep rupees 55 lakhs in the bank account for several years.
Sir, there are two aspects. If you say that you are an unemployed, you can't come and say that I am not supposed to give a 5 lakhs rupees in my keep 5 lakh rupees in your account.
Look, on the date of application, I have no difficulties.
No, sir. The difficulty I'm telling you, sir, the difficulty is because if the criteria is that only an unemployed youth
No,
are
I'm
eligible to apply,
I'm withdrawing my submission.
then
I'm
I can
withdrawing my
understand
submission.
what you say, but there is nothing.
There is nothing.
Nothing in this.
But at the same time, kindly consider rupees 5 lakhs for last 1 year.
That is what I understand. But now the question is,
So
whether it is
far
so
as unemployed is
unreasonable.
concerned, I am withdrawing. But at the same
No,
time,
at the same time, suppose a 5 lakh rupees preceding 1 year, is it so unreasonable? It's absolutely.
I'm
it is
leaving this
absolutely
point.
a policy decision of the government.
I understood.
What eligibility criteria they will put, because it is not offending any of the provision of the act or the ordinance or the orders.
Plus,
Kindly consider.
the whole intention is to ensure supply of an essential commodity. If the government wants the supplier to be solvent in public interest, how can that be
But
offended?
now
How
today,
can anyone claim
so
that
that
I will
today,
have a better-
entire ration article is without any cost. Today, entire ration article is free by the central government. No money is required.
Sir, you are required to operate the fair price shop with various
So far,
infrastructure.
stockroom godown is concerned, that I shall show. But kindly take note of, my lord, I along with another person jointly apply, not even a partnership. Kindly consider, jointly apply.
Then you are a group of individuals.
Yes, then not required. Kindly come to page 8, condition number 8. The applicant, not the applicant.
Therefore, we have asked you,
In case of individual, only applicant.
does it have any rationale with the object sought to be achieved by the control order? We are asking you to show the control order.
My
which the
junior has got.
advertisement has been issued.
Just a minute. That is in the single bench, another matter is going on. Just they are bringing. Only, my lord, the individual. And when you understood that these clauses are impractical and withdrawn the same only, saying, but in respect of the previous vacancy, it will continue. You have understood whatever I am saying, that has been accepted by the state. Past 5 lakhs to 2.5 lakhs.
No, you were referring that particular notification. The government says that there has been a lot of litigations which are pending in the High Court. And on this score, these litigations are there. So we have decided just to avoid these litigations, because the essential, it's a case of a essential supply.
But this is in respect of MR distributor.
Not to any privileged class, but to an socio-economical impaired persons who are entitled to benefit. Now you said it is now free. The objective is very laudable, because they should not remain. At least they should sustain with the amount of the
Economic viability.
the energy which the body requires to keep one person alive. So this is what they really wanted.
Well, relying on the court cases, distributors has been withdrawn. So far dealers are considered.
But the question is that, suppose these policy decisions are taken by the government based upon the present scenario and the problems which the government has perceived in course of time. The policy is amended, the policy gets changed, but the question is whether it has to be given from a retrospective effect or from a prospective. There may be a question that may come. Subsequently, the government may decide to whittle down this particular the conditions. But the position as it stands as on 2020.
On the date of application.
On the date. What the law says, the first thing is, what in future has come, we are not concerned.
Unless there is a specific mentioning, it should not be retrospective.
So far as the dealership is concerned, the government has not taken any decision as of now.
Yes.
That is a distributorship.
No, that I am showing to be a lordship.
And secondly, even if
so far distributor is concerned, considering the court case, so far dealers are considered no consideration, impractical. That's I have handed over to your lordship.
Maybe
50,000 only on the date of application. From 5 lakhs to 50,000 only on the date of application. Kindly see.
That is what they wanted to.
Not court case, only impractical.
Oh, correct. But that is in relation to this particular. You applied having fulfilled this.
I have not applied. I have came before this honorable court saying, withdraw this, allow me to apply. I could not apply due to such unreasonable, impractical condition. I am unemployed youth. I have rupees 5 lakh on that day also. But 1 year back, it is impractical, it is not possible. And why this condition? Joint application, you can apply in anywhere. Joint application, you may be a bank manager, you may be officer. Kindly see, individual. Wait. Wait to page tab. Well, it starts from 1.3.
Corporate. After all, it's sure. So terms and conditions of the benefits of this particular scheme, they are not.
Where is the particular control order regarding running of the fair price shop? The rules, terms and conditions of running of the dealership.
Clause 20.
Clause
20.
That is an engagement of the dealer.
Dealer.
So no, my brother is asking where is a clause relating to running of that particular shop.
Duties and responsibilities of the dealer. Where is that?
Clause 19.
19.
Page 1.14. Bottom. Right.
1.12.
1.14.
Part 3.
My lord. Part 3 bottom. Duties and responsibilities of the dealers. So far the finance is concerned, nothing will be found.
Display. This is what is after appointment. Particulars of ration cards, date registration, display, maintenance of the stock, and regulation for storage and sale.
No money is required, my lord. I have submitted paper lordship to their entire ration articles without any cost.
But now it says that this person already a license of dealer or distributor wholesale, he is debarred. Then since two is the member of the local body, it's big deal. But what he says is that individual something here it says person, it's person. In person, this is what holding a license of a dealer or distributor or wholesaler in his name or a person whose relative already has a better juristic person having a as well.
করছে কেন টাইম না নিয়ে এত বড় মামলা পারবে সামলাতে এইখানে মামলা করতে সময় সারাদিনে মানে
sheet mentioned in class 3 applications sickness shall be invited from but one is cited in the consent just not decision about what is the form already something different. And then let us test this. Applicant must be an adult Indian citizen or citizens. Already be said. I believe it can be individual. Actually, should be a permanent. If it is individual, correct. Individual, I do not know, but he's saying that partnership is not an individual. So in the agreement, not be a resident. Is it what he wants? Not be a resident. This is a discrimination. Yeah. It's a partnership. Says that applicant in case of an individual should not be employed in any But in case of a partnership, this clause is not applicable. This is what he said. Some penalty can from an individual permanently resided in a concerned subdivision of a registered partnership. The registered partnership form self group cooperative with notification. Absolutely. In case of a tea garden area, state government to only tea garden authorities are the same. Such like the best legal dispute. So there is a thing has been done. This is undertaking was given that we cannot proceed on that basis.
There was an entry order in this matter.
Your Lordship, obtain an undertaking from the London Advocate General at the
They will not proceed. Sir, what you are saying is that control order, there is a prohibition which is apparent on the face of it. And there appears to be some kind of a bloodness in the submissions. Please look at the situations where clause at page 1.19, clause Roman 3 small a. Following persons shall not be eligible to apply for a license of a dealer. Correct. Namely, the person holding a license of a dealer or distributor or wholesaler in his name, or a person whose relative already had a dealer or such and such, they are debarred. Then a member of the local body is debarred, local authority debarred, Panchayat Raj institution, board, corporation, or members of the legislative assembly or a member of the parliament during his tenure in such capacity barred. Then a minor or person of unsound mind, person convicted under the criminal court, the criminal proceeding, person holding a post in the establishment of any state government. Kindly visualize. It will not take 2 minutes time. Don't worry. A person holding a post in the establishment of any state government or a central government or an authority or a body, self-government, established or constituted under the constitution, these are all barred. Then a limited liability partnership, kindly visualize, barred. And then it says a corporation or a company, they are also barred. They can't apply, provided nothing in this clause shall affect, because it came later on. So continuance was not affected.
16th December 2020.
Whatever.
This is amendment.
16th
December. Kindly see bottom. DA has been substituted on 16th December.
No, 3A.
Yes, everything. 3A. Bottom.
14 December 2020.
16 December.
Oh, with effect from.
My lord.
It was budgeted on 14th with effect.
6th March 2020.
Oh, this was prior there too.
Yes. That was there. This also cannot be given back retrospectively.
It was inserted, actually. Not substituted.
Now company partnership that has also been stopped. Now no company can apply. But at my time.
No, that is very much clear.
Yes.
It says that continuance of the other will not get affected by this. So it is always made prospective.
What I have submitted before, actually, a company keeping rupees 5 lakhs can apply in all over West Bengal in every vacancy. Is it not discriminatory?
We were reading that particular.
There is no restriction.
This clause 3.
Even two brothers jointly can apply.
What was the earlier one? Can you show us because clause 3 was amended with effect from 9/8/20, substituted by with effect from 9/8/2021. Clause 3? Just 3. This is 2. Clause 3. Yeah, this one. This is 2. 2 is subclause 3 and 3A substituted by clause 1B. With
all are subsequent to my vacancy.
For existing clause 3, which was earlier amended. Where is the unamended clause? Can you show me the unamended clause 3?
What was the position when the advertisement was issued? That is relevant.
That all are have been recorded in the advertisement itself. I can show, my lord.
No.
I can show. Before amendment, what was the provision?
Counsel, what my brother wants is that there are certain embargo, there is certain, I think
in that case,
conditions have been imposed. And what my
amendments?
So far as the corporation means the company is concerned, we can understand because of this clause proviso inserted therein, where it says provided that nothing in this clause, that is the clause 3A, shall affect the continuance of existing license of a dealer. Means, if they are a company, there was no license, then it will continue even thereafter.
They'll continue.
They will continue even thereafter. So these embargoes are there. We just wanted to know that what was those conditions there
before amendment.
Because in 3, it says that it was from an individual permanently residing in a subdivision registered partnership firm. This is what I really wanted to know because these were inserted with effect from 28th of August 2021. So this was for an individual and registered partnership firm. This is what its incorporation is. From an individual permanently. This is what permanently is signing in the consent of subdivision, which was not there. This was the word. From
next I shall. I will follow again.
Pick the position.
But that notifications. You also got that notification on last occasion. I'll hand it over, my lord.
Yes, there is one notification.
Yes, one of 3 pages. Thrice it has been changed.
December 22.
Thrice it has been changed. First one was 18 December.
No.
2.5 lakhs.
This is not the issue anymore.
No, this is not an issue.
The amount is not.
Understood.
For why are you relying?
Unless it is the retrospective. But thinking of the state, what I have stated in my writ petition, that was the consideration of the state also. They thought it fit that it is impractical, irrational.
Something which is not there in the order, and something you are including into it, which does not appear on the stay. The state has already given an undertaking not to proceed. So it is better to send it the matter by send back.
Actually,
Which and let it be decided. Ensure expeditious and deserved. That's the whole difficulty when the state does not appear. And then the application for recalling will come that we were stuck up somewhere.
Your Lordship, kindly dispose of the matter because
So
possibly,
we wanted to dispose of the matter. That
possibly, they are also not interested. They are going to declare the fresh vacancy with the present clause. What is my instruction? I have informed. So far the distributor is concerned, they are also declaring fresh vacancy with new clauses, also dealers. But in fact,
So this proceedings has served its purpose.
because in all over West Bengal, they are declaring fresh vacancy.
no, if they come and say so, then we can dispose of the appeal and we can also.
Your Lordship, either way, dispose of the matter. Either way.
They dispose of the main writ petition as well.
Your Lordship, that was the intention of
So
the Lordship.
I tell you, the difficulty is because it is against the refusal to pass an interim order. We can record all this. Suppose if we pass an interim order, it will again go into the single bench.
No, it was fallen from your Lordship that your Lordship will consider and dispose of the entire writ petition.
That's all. We wanted to do it, but in presence of this, because at that point of
But I have argued the case. Now your Lordship deliver it, whatever may be judgment.
why don't you go and call the Advocate General now? We will dictate it in his presence. Can you call him?
But today I have another matter is going on.
No, you go. You have argued it. We will not, do not want you.
My junior will be there, my lord.
Yes. Please, we do not want you.
May I leave my...
Yes. Matter has been heard many a times. We can't.
Extremely sorry, my lord. Another matter is called on.
No. Yes.
The books are there, my lord.
Yes.
My lord, I am for the appellants. Is my lord the substitution application filed for the last occasion? Can 2, my lord.
My lord, Advocate Shivashi's ghost relative was died on, and in this reason he could not come. So please, matter.
See, the substitution application is here. Where is the difficulty? You are the advocate in record.
Yes, sir.
Yes. Be here. Substitution filed?
Yes, my lord. Copy served also.
No difficulty. Let us do the application to now. Who died and when died?
My lord, the died, appellant number 1 died, my lord.
Appellant number 1 died on 4th February
2024. My lord.
So we are
within time, my lord.
So we are substituting. Are you in a position to represent them?
Yes. Yes.
Have you secured the Vakalatnama?
Yes. Already filed. Yes, already filed.
Without substitution, Vakalatnama filed.
So the department says we have to enclose the Vakalatnama.
No, this is here.
Yes.
You are not making an application, sir. Who is making? Momita Das is making an application.
No.
Then
Ganguly is making the application.
Who?
Payal Ganguly. Payal appellant number 2 is making this application.
So why the Vakalatnama Momita is annexed to this application?
That's the direction of the department. I have to.
Unless substitution, how can you?
That's why, that's
who says in the department? They know the law or you, the lawyers? What for you are here?
Lord, we have to already affirmation done. Thereafter, department says that we have to file the.
Who has said so? I just wanted to know his name. Who said so?
From the department.
And what is their understanding? I just wanted to know.
Absolutely. Unless substitution, we cannot appear represent them. That is the things.
But who said that the Vakalatnama has to be?
It is not even in our brief, but department.
Can you bring? Anybody can show that who is the gentleman who has done that? Which department?
Where is my clerk?
Which department says so?
My lord, the matter was sent for the affirmation, my lord.
Then
The
who? The oath commissioner has said or what?
Yes, from the department says they have to file.
Department means the,
Well,
at that
obviously, oath commissioner, my lord.
oath obviously will not do.
Supposed to only do that. We have said on the last. We have nothing to do with that. That defect or not a defect. We have nothing to say. It is the department that will notify them. And we should only ensure that the gentleman who is there is the gentleman who is there. That's some identity. You can ask for whatever the documents. Very interesting to understand that there are two appellants. Appellant number one. Appellant number two. Appellant number two is intended to bring the heirs on the day of the appellant. And later on, there is no difficulty. Appellant number one, the heirs may also not look at. Sometimes it so happens that they may not be interested in pursuing after the death of the predecessor. So they are to be substituted as. How can she has to secure a Vakalatama to something? This is what I can understand. If Bhumika makes an application seeking a substitution, I can understand the Vakalatama. But she is not making. This is a file application. But number two is making. Why the Vakalatama is
And below the prayer portion also, they took the department, took the signature of Monica Das.
Who is the gentleman? Tell us.
The commissioner, my lord.
Oath commissioner?
Yes, my lord, we have affirmation.
Who is the gentleman who has done it? On 19-2? AJ, who has signed it? Ask him to appear. Just wait. Ask him to appear. Batao, who is the person? Tar signature touch. Call the next.
My lord, item number 8 to 10, I am appearing on behalf of the appellant, my lord, led by Mr. Mukherjee in this matter.
It is appearing on behalf of the de facto complainant, your lordship. Mr. Molay Bhattacharya is appearing on behalf of the de facto complainant.
What is this matter?
My lord, it's a criminal appeal, my lord.
Yes,
It's been assigned to your lordship.
Everybody was mentioning, everybody was very eager, and now asking for an adjournment.
My lord, I am for the appellant, my lord. I am led by Mr. Mukherjee, my lord.
Argue
I am just praying for
on the ground of Mr. Mukherjee and on the ground of some. We don't. Mr. Mukherjee came, he started. We wanted the hear out the matter.
My lord, your lordship would kindly, my lord, comes to page 2 of the.
Who is for the state?
My lord, I am one of the appellants, my lord. Hearing 85 of 2021.
Yes, we'll have to do it.
My lord, may I? Oh, my.
They have to, whatever. They have started.
My lord will kindly comes to my lord.
State, my lord, because the goes and because of Bandhavak.
Yes.
My lord will kindly comes to page 2 of the paper book, my lord. It is the written complaint, my lord, pursuant to which the FIR was registered for investigation.
What is the utility? Ultimately, the case was committed to trial.
My lord?
The case was committed to trial after the charge sheet was.
After charges, yes.
Then FIR, what is the utility? Are you showing that some portion you have shown it to the witness to get it exhibited?
No, my lord, but there are some portions which your lordship will find it relevant when your lordship will read the evidence of PW1.
No, it's not necessary. Then you'll have to place those particular statement and get it exhibited.
My lord, in that event, my lord will kindly comes to page number. My lord, page 6 and 7, your lordship, 5 to 7, your lordship will find it's the inquest report, my lord. Well, at page 12 is the post-mortem report. In the bottom part, my lord will see death was due to the effects of above noted injuries, ante-mortem, and homicidal in nature.
Yes.
Now, my lord,
So that's why the case has been committed to session trial.
Sessions.
Anti-mortem in nature.
My lord, PW1 is at page 7, my lord, of the paper book.
Yes. No, that is an investigation report.
My lord,
page 5 is the investigation report.
page 15.
Page 7 is the
I stand
continuous-
corrected, my lord, page 15. Actually, there was written page 7, my lord.
What page 7?
My lord, it is at page 15, my lord. I stand corrected, my lord.
Yes.
Madam,
Yes.
which are you reading?
First.
PW1.
Yes.
Well, before, has my learned friend showed your lordship the charge? The charge.
Charge sheet.
No, the charge framed against him.
Yes.
Madam, please comes to
That
page.
is after charge sheet is filed.
Yes, madam.
What is?
And that starts the trial.
Yes, that was committed to trial thereafter.
Yes.
Was he was taking us to FIR. I say, what is the utility when the case is committed to session trial? The evidence has come.
Correct.
If there is something, then you will have to put those before the
And
witness
then come
and
back
get
to-
it,
then
get
come
it
back-
marked and exhibited. Then you
Yes,
can
then
rely.
come back, right.
Otherwise, not.
Right, absolutely right, madam. Absolutely. You're absolutely right.
Yes. Where is?
Well, the only irony is you all never practiced criminal law.
Yes.
Because you all were civilian, we were criminals.
No, it's not. Anyhow,
Yes, ma'am. Place 13. 1-3.
Yes.
The charge.
Yes.
Firstly, that you honor about, Malad, 4 accused on the top, Malad.
Yes.
Then, that you honor about the 27th of January 2011 at Khan Marriage Hall under PS so-and-so did commit murder by intentionally causing the death of Javed Ali, alias Mohammad Javed Khan, in furtherance of your common intention to commit murder of the said Javed Ali, and that you are thereby committed an offense punishable under section 302 by 34. Right, Malad?
Correct.
Now, as your lordship knows, Malad, 302 by 34 requires 3 Ps: presence, participation, and prior meeting of minds. So these are the 3 required of 34. On or about 27th and so, knowing or having reasons to believe that certain offences, to wit murder of Javed Ali Mohammad Jai, punishable with death or imprisonment for life, having been committed, did cause certain evidence of the said offence to disappear, to wit the dead body of the murdered Javed Ali, and the offending weapon used in commission of that offence of murder, with the intention of screening the offenders, namely those forced persons, my lord, from legal punishment in furtherance of your common intention to disappear those evidence for screening the aforesaid offenders from legal punishment for commission of murder of the said Javed Ali, and that you thereby committed an offence punishable under section 2 and 1 by 34.
Correct.
Now, my lord, what I was trying to say from this is there is no eyewitness to the occurrence.
Obviously.
There's no eyewitness. If there was no eyewitnesses to the occurrence,
Circumstantial evidence.
but my lord, circumstantial, you're actually right. So the 2 things are there, my lord.
Last in theory.
Last scene, that's what your lordship, I will argue on that only, my lord. The last scene principle. Now, the last scene principle would mean that there are reasons to believe that on the 27th of January, we common intention to be committed the murder. And subsequent to committing the murder, we had disappeared the evidence where the body was found in a septic tank. Now, my lord, your lordship keeps this in mind. Now, my lord, before I go to anything else, my lord, I would like to bring your lordship the doctor's evidence, because that will help me a lot. Now, let's come to the doctor's evidence.
You are representing Mujahid.
Mujahid Khan.
Okay. Yes. Doctor's evidence at
For the number
page. At what page?
Yes, ma'am. My lord, Biplab Shihi at page 41.
41.
My lord, I think your lordship should see the original, because the type copy.
Yes, a bit.
My lord, your lordship, my lord can see it. See that?
Not a type copy. Actually, these are all photocopied.
I know, my lord, you can't read. So, my lord, if your lordship sees the original, my lord.
Yes, first paragraph is a very difficult one.
Second also, my lord.
No, second I can.
Now I am posted as assistant professor and medical college. I have been in the same so-and-so, my lord. I couldn't read the dates.
No, I have been same since 2010.
Yes.
On
31/11.
31/1/2011.
Yes. Well, then I call on examination. Well, let's come to on examination.
Yes. I found one beheaded dead body.
With
partly
decomposed state.
decompositions appears marbling.
Marbling.
Yes.
Body was stained by blood, mud,
mud.
and sand particles with foul smelling, with wearing apparels.
Yes.
So and so.
Green. That was.
Pants mixed by blood,
Yes.
sand, and blood.
Yes.
Well, your lordship sees the original. Then it will be helpful. It original to down, my lord.
Body with.
Barcode. Barcode.
No, I don't worry. Is a witness number.
One is 5.
5. No. No. Yes. Beautiful. PW4. Is PW
5, my lord.
5. Yes, we got it. Yes, I am posted as an assistant professor under the Forensic and State Medicine Medical College.
Well, can I read it out so that your lordship will
I am reading out.
Okay, my lord.
So that you can compare.
Yes,
I have been in the same post since 2010, full stop. On 31st January 2011, I had been in the same post in same capacity at the same place.
Right.
On that day, I conducted the postmortem examination of Javed Ali, alias Javed, 18 years, Muslim, male, in reference to a Bhadreshwar PS UD case number 4/11 dated 30th January 2011 and Bhadreshwar PS case number 12 of 2011 dated 30th January 2011 and section EI GD number 2953 dated 31st January 2011 and FM 19 or such and such at Kolkata Police Morgue. The dead body was identified by the constable number 2548, namely Ranjit Sarkar of Bhadreshwar PS. On examination, I found one beheaded dead body.
Already decomposed.
No. The dead body. Body. Refn black. What is this? Retin black. Pothin stage of early decomposition. That's a medical term, I believe.
Yes,
appears marbling. Body
marbling is a
correct. Body was stained by blood, mud, and sand particles, with foul smelling, with wearing apparel, greens, white half shirt, with full jeans pant, mixed by mud, sand, and blood.
Yes. On examination.
Following injuries were noted. Head was separated from remaining part of the body at the level anterior null, just above the hyoid bone and below of first cervical vertebra, posterior, with evidence of multiple chop wounds with verifying length and depth, transecting all the structures of the neck at that mentioned level. One incised wound measuring 3 inches into 5 inches up to muscle depth over left jaw.
Obliquely.
Oblique word is not correct English. Obliquely placed. Size. Placed with trailing medially.
Yes.
One incised wound measuring 1 inch into half inches up to muscle depth over right angle of mandible.
Yes, ma'am.
One incised wound 2 inches into half inches up to muscle depth over a front of left mastoid placed vertically.
Yes.
Incised 3 inches into half inches up to muscle depth. Traversally.
Acha.
Traversally 2.5 inches above
Supra-sternal notch. Right.
Then the multiple. Now we can read the rest portion. No.
Same.
Then
Same.
now what do you want to say?
Well, what I want to say is,
Yes,
well,
tell us.
the charge speaks about the incident taking place on the 27th of January.
Correct.
Right, my lord. I will just read one line. My lord, page 43. Page 43.
What is that?
Well, the doctor's statement, my lord.
No. Means
They speak about that the death occurred 24 to 36 hours before the postmortem was held.
where do we get it?
My lord, in the middle part, my lord.
This is.
My lord, from the early.
Yes, I got you. Yes, tell me. We got it. From the evidence of early decomposition.
Yes.
Yes. Then
It can be presumed that the death, well, it can be presumed then, that the death.
it may be presumed it says.
Maybe, well, let us understand. May we presume that the death was caused about 24 to 36 hours prior to the postmortem examination. Now, my lord, please comes to the PM report at page 12.
What is the date?
31st.
31st is the date.
Yes.
27th. So you want to correlate it? If
It can't be
goes-
correlated because 29th.
Cannot go below 29.
Yeah, I'm grateful. I'm grateful to your lordships. I'm grateful to your lordships.
Yes.
Now, that's the first limb of my argument.
Yes.
The second limb of my argument, my lord.
Yes.
The second limb of my argument pertains to the inordinate delay in filing the first information report.
That is the incident of 27 and
30th.
30th.
Now, what happened, my lord? On the 27th, while he was having the meal, the deceased was called by Shamim, one of the appellants before your lordship, to come to Khan marriage hall for the purpose of playing carrom. That's 1 o'clock in the afternoon of 27th. Right? When they were going, Mujahid and another gentleman, they were standing in the door when he entered. Now, Mujahid was the manager of the said Khan ceremonial hall. Thereafter, my lord, what happened? He was supposed to join his duties at 2 o'clock. PW2, the mother said, he did not come back. In the evening, we searched for all the places. Now, what has troubled me is, when you have seen this gentleman, that is the deceased, going into the Khan Memorial Hall, marriage hall, you are aware that the last seen principle, as my lord has said, last seen principle was that I had gone there. Now, you searched the entire places of Bhadrashwar PS, but never searched the memorial hall, marriage hall. Now, as a consequence, my lord, what they do is, on the 29th, they file a missing diary. 29th. Then, my lord, on the 31st night, 31st night, my lord, all of a sudden, we do not know when the police was informed or when the police came, because the discovery, according to them, was 03:45 hours. That's early morning. And the report to the Thana was at 4:50 a.m. Right? Now, my lord, as your lordship knows, in these cases, any unnatural cases, there has to be an UD case. Now, that UD case is under section 174 of the Code of Criminal Procedure. Now, that was started at 4:30. Now, in that 4:30, my lord, the said was that they found the body only to that extent. And he was murdered on 27th itself. On the 27th itself.
How they came to know that it is the murder, he was murdered on 27th. And
this is nowhere. But with due respect, let us hear the PP. Nowhere in the appeal, in the evidence of the they have said how they could know that the murder took place on the 27th itself.
So, yes.
So, now to see the conduct. The mother speaks about the Mujahid and all being there. So, as my lord has said, so the question is 4 of them were there. One brought him, and from that time, after 2 o'clock or 27th, he was.
One brought him, 2 received, welcomed him.
Yes, who was standing at the door.
That's a welcome.
Yes, right, welcomed him. Then, my lord, we don't know anything in the sense till 30th. Because on 30th, my lord, the best part is the police goes upstairs. When they go upstairs, they go and say, we could not find anything. Then they come down, and then, my lord, at the back gate, near the back gate where the septic tank was there, they go by themselves and have it. Now, my lord, as your lordship has just read, when the doctor came, the examination was done. His body, the dress, was with sand and mud. Now, sand and mud, and if the incident had taken place, not a single blood stains were found or trailing blood from the top, because they said they killed him upstairs and then brought him and put him into the septic tank. So there has to be a trail of blood when such a gory act.
They have been also booked under those clauses where they say you really destroyed the evidence. Those were
that one was the second one I read, 201 by 34. So now one of the allegations against me is, the only allegation against me is, below the water tank on the top floor, a statement which I made under section 27, there a lungi was found.
So recovery on the basis of your statement.
A lungi. But as your lordship has seen from the doctor's statement, he was wearing a jeans on that date. He was not wearing a lungi on that. And the body also was of lungi, of shirt and pant, jeans. So and the blood stains were there, Malad. The FSL has made it very clear we could not make out the matching with the bloods.
Blood stain on a lungi.
On the lungi.
Yes.
So, Malad, what we have before your lordship is the statement of the mother who saw them going for the last time, and the statement of a betel nut shop owner
who have seen going through.
Now, the best part of that is, Malad, if I may read it out from no standard.
Yes.
Now, what it sees, BW7, who is that betel nut shop owner, very interesting. The one your lordship will please comes to 51. Your lordship can read this one. Well, I'm reading the third paragraph. On 27 January 2011, at about 1:30 p.m., I saw Chand, Shamim, and Sagar to take Javed towards the Khan marriage hall from his house, and they took him to that Khan marriage hall. I also saw Ghazi Khan and Mujahid at the gate of Khan marriage hall. Mujahid was the manager of the Khan marriage hall. Thereafter, they took Javed on the first floor of that Khan marriage hall by using the staircase. Then sees the next paragraph. At about 10-11 hours in the night, on 27th, mother of Jahid came to me and told that Chand, Shamim, and Sagar took Javed Khan for playing carom there, but he did not return yet. Thereafter, I searched for Javed in our locality in the night. On the next morning also, I searched for him. Malad, both of them, if your lordship goes by the last in principle, both of them have seen they're entering the Khan marriage hall. So though they don't make a search of that Khan marriage hall on 27th, 28th, 29th. And this witness has specifically stated, Malad, specifically he has stated that on the 28th and 29th, Khan marriage hall was open.
Yeah, do we get it?
I'll get it. I'll just show you. Just give me a second. Now it comes to page 54.
Yes.
Now, on page 54, about 10 lines from the bottom.
Whose evidence? Same gentleman.
Same gentleman.
Yes.
On 28th and 29th, has my lord got it well?
Yes.
On 28th and 29th January, the Khan marriage hall was opened and Mujahid was there. It is a fact that on 28th January, 29th January, and 30th January, marriage hall was opened and Mujahid acted as his manager. Well, if I had done something wrong, the normal course of event would have, I would have absconded. I stay there.
Why?
No, normal course, if I've done something wrong, my lord, to flee away from the police.
No, it may be opened. It does not mean, because it has not come up, that there was any ceremony which was organized during these.
No, your lordship. I get your lordship. Your lordship says some function was held on that day. That is not there. But it was open. Now, think about it. If the incident had been taken place.
Yes.
If the incident took place on the 27th,
yes.
28th was open, 29th,
yes.
No smell. A putrefaction, decomposition. After 22 hours, putrefaction starts.
The postmortem report says that it was at the.
No, postmortem report 36 hours back. Well, take 36 hours back.
Yes.
We have to go to that.
Yes.
Then it is. Now, come to the last line of this ban. I did not make any search in the Khan marriage hall on 27th, 28th, and 29th until the police came in the night of 30th.
Correct.
But he saw them going in. This is the basis of the conviction of the present appellant.
Yes.
Now, let's see. Page 55, middle part. Besides our mohalla, we also went to Barakpur and Titagarh for making search. We went to the hospital, Pudiswari, Barakpur and Titagarh. We 3 persons went to Barakpur, Titagarh, but neither of the family members, Javed, accompanied us as they went for search at other places. What was the necessity? You are saying for the last time at the marriage hall. Ultimately, on the 30th, the body is found from there itself.
Is it not probable that somebody cannot guess or cannot presume that the person will be beheaded in this fashion? Everybody at that point of time, because the body was not recovered, they must be of the view that he might have gone somewhere else.
So then when last scene doesn't come?
So
then last scene doesn't come?
Question is, when the body was found, because he was not seen thereafter, that is from 27th.
He was not seen after 1:30 p.m. After 1:30 p.m. he was not seen.
Not seen.
Correct.
And the gentleman whose name has been diverse was only the contact person or the person in his contact till he went, missing, whatever.
I use the word missing. Yes.
Missing or is not seen at all.
Achha, right,
not seen at all.
Yes.
So this is what he wanted to correlate, that ultimately it came. What will happen? Suppose, let us see in that scenario, a hypothetical example. Somebody was taken by a
X,
person,
Y, and Z.
by a person, say X, to play in the field. He went. And thereafter, the person is found missing. The X was the far last contact of that person. And maybe there may be a cases that X was also interrogated, says, I do not know where he has gone, but he was not found. And ultimately, after 5 days, the body from a pond is recovered in a decomposed land. Do you think that last in theory cannot apply because it was a gap of five years?
Yes.
Because the principles of law in this regard, that last seen theory must be of in a very close proximity of the
I'll
time.
give that. I can get full to your lordship. That proximity, I will bring it to your lordship.
Sure.
My lord, going for a walk?
No. Oh, just for 2 minutes.
No problem.
2 minutes. No, this is under the medical compulsion.
to inform the learned advocate general. I have intimated the same to the learned advocate general, and he is arguing in a case in courtroom number
Volume
1.
at 2. Volume at 2. Yes.
Very item number 7, my lord, we should come back.
Pass the order. Don't worry. We are in the midst of a hearing.
Well, before I go to the next point, Malad, there's one thing I must show to you, Lordship. Very interesting.
Yes.
Malad, please comes to page 46 of the exhibit file.
Yes.
Malad, this is the GD entry which was made by the father of the deceased on 29th, 1577.
Not returned. So,
See from simple sense. Obviously, father cannot expect.
Malad, any whisper of Khan marriage hall, any whisper of last seen together, any whisper of the names of these 4 boys? Who has made it? The father. PW1, page 15 at the bottom. A lot you will see. So the going there, the last seen together principle, if a lot sees this, goes away. Yes. Now, Malad, when you're on that exhibit file, Malad, one thing I will show to you, Lordship. It is out. Malad, this is the dead challan. Dead body challan. It's an exhibit. Malad sees, when did the body go? Recovery is on 30th in the morning.
Right.
This is in the early morning on 30th. This is on 31st. Sent by rickshaw.
Sent by?
Rickshaw.
Yes.
Lord, you will get it there itself.
Yes.
12 kilometers.
Yes.
Right, Manoj? So we are not aware of, from after the UD case was started, on 30th of January at 4:30 hours, which ended at 5:15 a.m. Where was the dead body? Still, this was sent for postmortem.
Yes.
More than 24 hours.
Yes. Yes.
We are filing.
Yes.
Manan, what I'm trying to impress upon your lordship is very simple, Manan. That the incident as sought to be projected by the prosecution could not have happened in the manner sought to be projected. My lord will now get the reasons why, from the GD entry, your lordship will get the reasons why nobody went to Khan marriage hall. They went throughout the different places. So if your lordship trusts us on that, then the whole last instance principle goes away. Because one not interested relative witnesses says this.
Yes.
Now, my lord, please comes to PW 15 in respect of the blood which were found in the Loki and others, my lord. The blood stains, my lord.
Yes.
It has been specifically stated, my lord. The ways there, I don't want to show it to your lordship, waste your lordship's time. My lord, it has been specifically stated at page 75. Starting at 74.
Yes.
When it comes to the cross-examination part, the Napala and Abhojali was recovered. All were nothing to be nothing was found there. It was disintegrated and small, not sufficient. Well, I can show your lordship the exhibits on that.
Yes.
They will file the my lord के देखी नहीं final है ये होता.
We found rust. G was not sent to the cerebral.
But this is the
Yes.
my lord has seen it, my lord. So it's neither here nor there. Nothing could be found. And see the serologist report, nothing could be found.
No conclusive opinion can be made because it was.
That's what I'm saying. So, but if it is not conclusive, I get the benefit. Now, my lord, please comes to, as I was telling your lordship, where was the body prior to sending it to the PM doctor? Now, my lord, if your lordship comes to page PW7 at page 51. Well, I'm not reading the whole thing, Malad, so that I can get the points to your lordship through. If your lordship has any confusion, can ask me, Malad. Page 51. Malad, please comes to the last. This is after the inquest is done. Then, Malad, the inquest finishes at 5:15 in the morning. Then sees Malad. Thereafter, police send the body to Bhadreshwar PS.
Yes.
So, Malad, on 30th, the body which was found is being sent there, and after 24 hours, in a cycle rickshaw, that body is sent for postmortem examinations.
Yes.
Malad, any clarification I would give? Well, 49.
In the body. Yes.
On page 49, the dead chala. तो बोलना And on the top, it is 48. 48.
Yes.
So, Malad, what we have now, Malad, first I told your lordship about the incident of 27th of the man dying cannot be done.
So what he says is the
Yes.
evidence as it appears
Of Malad?
Evidence. Evidentiary, whatever the exhibits
speaks about.
The 30th, there was a postmortem.
Correct.
And then what he says, this is the witness who have seen this Mujahid as a
manager of that.
Whatever. He has seen Chance, Sameem and Sagar.
Yes.
Together.
Going inside.
Correct. So this language which you are saying is that what he wanted to say is that after the body was recovered from a septic tank, an inquest was done. I was a signatory in that inquest.
Correct.
The signature.
Correct.
And thereafter, they say that the police, it says, police sent the dead body to Bhadreshwar police station.
Correct.
He's not supposed to know where the police is taking away the body. Then he says on 1st February, what he talks about is that postmortem was done on 30th. 31st, we don't know what has happened.
No, 31st postmortem happened.
What? I'm telling. And then on 1st February, what he want to say, the police came.
But that is when I've been arrested in the meantime.
And police took me to that particular, the
recovery part. The recovery part.
Marriage hall. And then we entered. So first is not a case when a body was taken away.
No, I'm not saying that, but I think I've got it wrong, Malad. What about, Malad? Just give me a second, I'll just clarify it.
Yes.
What I'm trying to impress upon you, Lord.
Yes.
Malad, the postmortem report is of 31st.
Correct.
The UD is of 30th.
Correct.
30th at 5:15 in the morning, early morning of 30th.
Correct.
The inquest is done.
Correct.
Now, Malad just sees the inquest. 1 minute. I'll just show 1 minute to your lordship.
Yes, we have seen that inquest.
No, not that, Malad. I'll only show. Your lordship has seen the inquest. Now, Malad, please comes to page 7. the last paragraph just above 10, page 7. One of the paperwork one.
I know.
Oh, achha, sorry.
The inquest report was obviously made exhibits.
Yes.
What is that?
Exhibit
number? Which one?
My exhibit it is. Just give me a second, man. No, exhibit P14 one. My exhibit 2. Exhibit 2.
Yes.
Now let's see is paragraph 10.
Where is exhibit number 2?
On the top, your lordship, you can see it.
Just come 14. 2 by 4.
It's 2 by 4, man.
This is exhibit 14. That's why I'm saying.
Well, the paperwork we were handed, well, there it says.
Anyhow, we'll see to it.
Can I get it out for your lordship? Give me
No, exhibits are in a very haphazard manner.
Oh, not serially. Not serially.
Not serially.
Oh, sorry, man.
Yes,
I'm
which
taking
one?
each one. Well, please comes to page 5.
5. Yes.
In 30th of January at 4:30 hours on the top, my lord. UT case number 4 by 11. Page 5.
Yes. 415.
450.
Yes. Yes.
Then, my lord, investigation closed on 30th of January 11 at 5:15.
Correct.
These are all of 30th.
Correct.
Now, my lord, please comes to the last page. My lord, page 7.
Yes.
Whatever may be the cause of death, to detect the exact cause of death, the dead body is sent to Inshura Southern Hospital with required papers for postmortem report.
Correct.
This is on 30th early morning.
Correct.
Now, my lord, please comes to the postmortem report. My lord, page 12. Page 12.
Yes.
My lord, see date and hour. There are 3 columns, my lord.
Yes.
Dispatch, receipt, and then, my lord, examination at 2:20 p.m. of 31st of January 2011.
Yes.
So, my roughly 37 hours after the inquest.
Yes.
So, the period between these, where was it?
Where was?
The body. Because according to the inquest report, he had sent it to Chitra Southern Hospital.
Yes.
That is why, my lord, I showed the death challan.
So what is the contradiction in this?
36 hours.
The contradiction in this is, my lord.
Since there is a gap of, because it is 31st, 30th, early morning, here it is 31st, 31st. So I wanted to say, where was the body for those 2 days?
Well, 48, page 48. My lord, see the date when it was sent from the Thana.
Yes. Yes. Yes, we got it on 30th.
One minute.
On 30th, it was sent.
No, receipt. The body is receiving where?
No. This is what you wanted to say. Postmortem report. The body is dispatched at 1:50 p.m.
of 31st.
31st.
Yes.
And then it's you say that so far as the arrival at the dead, I think the dead house means morgue.
It's 2:50.
Or whatever. It's
It's
2:50. And the examination at 2:20.
2:20 of 31st.
All I understand. So
And
your
this is on
contention is
30th.
that if 30th the body was recovered,
It was supposed
and
to
then
be
it
sent to
appears
Procedural
on
for the
31st the body is sent at 1:50. There is a gap of 36 hours
Yes.
or so. Then there is where the body was.
Yes.
This is what you want.
Yes. I'm grateful for that.
Yes.
Now, my lord, I would like the lordship to come to the IO, the investigating officer.
Yes.
But starting at page 79.
Yes.
Mala, I'm reading the whole here. In respect, I will read out, not part one, I read the whole.
Yes.
Now I am posted at Rishra Police Station and SI of Police on 79, Mala.
Yes.
On 30th of January 2011, I was posted at Bhadrashwar Police Station as SI of Police. On 30th of January, received a written complaint from one Maniuddin and forwarded the same to OC Bhadrashwar Police Station through Constable Aditya Nath Mukherjee. OC Bhadrashwar introduced me the incident case for investigation. Well, just pause here for a moment. Well, please comes to page 3.
Page
3.
Yes.
Received on, my lord.
Yes.
Received on 31/11 at 3:45 hours and forwarded the same to OC for starting a case as well through so-and-so of Telidipara town outpost.
Yes.
So the Bhadrashwar PS information was sent by this gentleman, IO, to the Thana for registration, which took place at 4:15. Now, but the reason behind why I'm trying to say this to your lordship is, whose information did the police come prior to 3:45 at the place of occurrence? There is no such GD entry. My lord is aware, PRB stipulates, even if you go to the bathroom, you have to make a GD entry. My lord, will I repeat it, my lord?
Yes, I got you.
Oh, I am grateful.
Yes.
So the Bhadrashwar PS case, according to this IO, he himself says it was received at the TOP, town outpost, and then sent to the Thana. But how you came to the place of occurrence? Because the recovery is at 3:30 in the morning. If it is at 3:30 in the morning, no case was registered at that time.
Yes. This is by a brother.
Yes, brother. This is by the brother.
Initially,
And the scribe is PW.
No, what is that?
Sorry, my lord.
His father
Lost the GD.
Lost the missing diary.
Yes, correct.
He says that his son is not found since 1 p.m. on 27th of
Right,
January.
right, my lord.
So this is what they say. They did not have any clue that what has happened to my son. The father did not.
Correct.
But later on, when it comes that the brother, that is on 30th itself, after that he came to know, and then he lost this diary. FIR and naming that person. So he has said that I know Bengali, but I cannot read and write.
Right.
So something was narrated orally.
Which could not have been translated into.
Correct.
Oh,
So
yes.
they have translated it in English, and thereafter after the entire translation is done, it takes time.
It
And
went
it
to
depends,
the Hon'ble, your lordship
depends
is right,
upon a
absolutely.
skill and potential of one man to another.
Will differ.
One may take 3 hours to get it translated. One may do it in 3
5
minutes.
Yes.
3 minutes. There is no difficulty.
No difficulty.
So he has registered after this, and then he says that I am putting my signature after being explained and read over that what I have said in Bengali. So he was satisfied about it, and thereafter and after he put his signature, the registration has to be done.
Correct.
So that was a time and a date. But in the meantime, if something has happened on the basis of a missing diary,
there's no such.
Why?
My lord, what I'm on, my lord, is on the
you are thinking about the 345 is a date when an FIR is registered. How can they go at
FIR is not registered, a complaint is registered, which is forwarded to the Bhodeshwar place.
How can they go in 330?
Yes.
This
because if you go at 3:30, even how could the police be there at the spot even before the FIR was registered? Even before 3:45, if I take that time to be registration.
Yes. Yes.
Well, it comes back to 79. Page 79.
Yes.
On 30th that I read, Malad, just on 27th of January 2011, at about 1300 hours, one Nizamuddin of Telinipara, Sheikh Agarwari Road, informed to police station that Muhammad Javed Ali alias Javed is a missing daddy
was missing from his house.
To that effect that one missing daddy was lodged to the police station being number 1577.
That is on 29th.
And see the first line, first word?
Yes.
On 27th itself.
Yes.
On 27th, there was no GD entry. The GD entry is on 29th. How could the IO say that?
No, that was on 29th. This missing diary was lost by the father.
On 29th, your lordship is right.
From police station that Mr. Such and such was missing from his house to that effect. One missing diary was
That
lost.
is what I'm saying.
So one has
if your lordship is
the language.
Is your lordship implying
the very bad drafting, but one should understand what was the intention. The intention was that
to
from
say
27th is missing, 29th I am lodging a...
No, so the contents of the GD entry speaks about 27. My lord is trying to impress us on that. Now the question here is, my lord, let us accept that to be correct. Accept it. That has been exhibited. Everything has been done. 1577. So then the question is, in spite of the GD entry, they never did anything. GD entry made. My lord is aware of, there is a provision under the Code of Criminal Procedure, which is 157, where any GD entry has to be inquired or investigated. Inquire if it is a non-cognitive, and investigation if it is a cognitive. Now, so that was never done by the investigating agency. But what I have to do in this lordship is to bring a semblance of doubt that the incident could not have happened in the manner as sought to be projected by the prosecution. That's my duty, my lord. So what appeals to your lordship, and I can only bring it to your lordship's knowledge. Now, after receiving the said missing diary, I, along with other police officers, started to search the missing person but did not find him. So an inquiry was held to ascertain the missing person. Then, on 30th, now please see this. On 30th of November, at about 3 a.m., please note the time. I had been at Akbari Ali Road and met with Muhammad Maniuddin, the brother of missing person, Mohammed Maniuddin, informed me that on 27th at about 13 hours, his next door neighbor, Mohammed Shamim, and his brother, Mohammed Chand, Sagar, both of Paikpara, Telinepara, called his brother Javed Ali for playing carom board at Khan Marriage Hall, which is situated in front of the house of the complainant, where Mujahid Khan, Mohammed Ghazi Khan, both so and so, were present there, and he suspected that his brother was murdered by the above noted persons. Now, my lord, if your lordship goes to the FIR, which is done subsequent to this time of 3 a.m., your lordship will not find anything about this. That the murder part is nothing there. On the basis of the said written complaint, myself along with Fos and Mohammed Maniuddin and his relatives and local people of the said area searched the missing persons in the different room, bathroom of Khan Marriage Hall. So this was on the basis of the 3 o'clock complaint.
That is on the basis of a disclosure made by the brother of the deceased.
And on that basis, they investigated in the Khan Marriage Hall.
No, it is not that. Please, because I want a clarity.
Please, my lord, I'm there also as well.
If you look at the preceding paragraph,
my lord, the 30th one.
Yes, it says that at 3 a.m., what he says, I met. He did not say that anybody lost the complaint, because the earlier paragraph is that there was a missing diary lost on 29th.
29th.
He said on 30th, I met with his brother of the deceased, who at 1 p.m. in the morning, 1 a.m. in the morning, who said that these are the persons who have taken my brother to a marriage hall. That is a marriage hall. And I suspect
that these folks have committed the offense.
Brother might have been killed or murdered. Then on the basis of the said written complaint does not mean that meeting there is a diversion or disclosure of certain facts. Written complaint was of a missing diary dated 29th of January 2000.
Is there any whisper
on
about
that basis? He continued and went because he was entrusted to do that. To find out. Then he went into this.
So, my lord, in the complaint or the GD entry 1577 of 29th, is there any whisper about us? Is there any whisper about the Khan Marriage Hall?
No.
So how could you go on that basis there? At 3 a.m. in the morning. There has to be a GD entry in the Thana that have gone to Telinepara town outpost to, as your lordship has rightly said, to investigate the GD entry of 29th. I am convicted for life.
Yes.
Then my lordship sees, on the basis of the said written complaint, myself along with Fos and Mohammed Maniuddin and his relative and local people of the said area searched the missing persons in the different rooms, bathroom of the Khan Marriage Hall. Later on, during searching 3:15, I found a dead body was lying inside the septic tank of the Khan Marriage Hall. The said septic tank is situated at the eastern side of the ground floor of the Khan Marriage Hall. With the help of Dome and local people, recovered the dead body from the septic tank, which was a beheaded dead body. Right, Ballard? So it's at 3 o'clock, 3:15.
Yes.
Right? Now, Ballard, I will sorry to trouble your lordship again. My lord, why I'm saying this, my lord, please don't get upset, my lord. Why I'm saying
No. It's a learning process.
Right, my lord, I'm grateful.
What is passing through our mind? We want clarity. Clarity of that.
Pardon me, my lord.
Our mind is still open. We are just trying to figure out.
My lord, comes to page 2 once.
Yes.
My lord, just read this FIR. At 3:45, the body is already found at 3:15. No whisper.
Yes.
Did the incident take place in the manner sought to be projected? With due respect, my lord, no. Yes. Then, my lord, I found a dead body was lying in the septic tank, so and so. The beheaded dead body was identified Muniuddin, Naim, and local people as the dead body of Javed. I informed the fact of recovery of the dead body to the OC. Then, OC Bhadrashar was informed over the telephone on the basis of the written complaint of Mohammed Mainuddin, Bhadrashar PS UD case number so-and-so, and Bhadrashar PS case number so-and-so has already been started, and also informed me that he endorsed the case to me for investigation. I prepared the Surat Hall report with the help of Constable so-and-so and Dome over the dead body of deceased Mohammed Javed Ali in presence of the brother of the deceased and local persons. Right, Malad? Then, this is the said Surat Hall report prepared and signed by me. The Surat Hall report is marked as Exhibit 2/4. I took photograph of the beheaded body by photographer Taposh Bhattacharjee. Thereafter, I sent the dead body through Constable 2548 Ranjit Sarkar for post-mortem to Superintendent Chishura Sadar Hospital. I have already told your Lordship, feasibility of this statement. For the said purpose, I prepared a dead body challan, which I showed to your Lordship. In my own handwriting, this is the said dead body challan marked at Exhibit 16. It speaks of a 31st. For the purpose of my investigation, I visited the Khan Marriage Hall and prepared draft sketch map with index in my own handwriting. These are the said draft sketch map with index containing 2 pages marked at Exhibit 17 and 17/1. The PO was middle room of the first floor, south-facing Pakka building measured about 16 into 16 and also 3 rooms situated in the said first floor. The PO was also the said septic tank where the dead body was recovered. Now, Malad, we have 2 POs. What are the POs? The top first floor and the second is the septic tank. Now, PO would be the place of occurrence where the incident took place. But if the incident had taken place on the first floor and then dragged down and put it into the septic tank, I would have appreciated because there was not a single blood mark from the staircase. And it's a gruesome murder. I'll use the word, being an officer of the court, when you wipe the heart, it pumps out, the blood pumps out. It doesn't dribble. It just pumps out of this. It goes out.
From the esophagus being slit.
Yes. So the question is, it cannot be a small quantity. And it will continue till such time the body gets into the rigor mortis mode. And rigor mortis sets it within 2 hours to 2.5 hours. So this is one of the... Then, I'll be honest with the Lordship, what I've been trying to impress upon the Lordship is, the incident took place, not in the manner, in a different place, and it was hidden here. Because that 24, 36 hours, that is something which is inures to my benefit.
Yes.
For the purpose of investigation, the said marriage hall was kept under lock and key. During interrogation, I did not examine PW1 as his statement was according to his written complaint. I also examined PW2, so-and-so, so-and-so, so-and-so. During investigation, I went to the house of Muhammad Shamim to arrest him, but he was absconding. I also went to the house of Muhammad Chand and Iftikhar Sagar at Paikpara, but they were absconding. During investigation, I have collected copy of the missing diary, being 1577, dated 29th of January 2011. I copied the same from the original diary in my own handwriting. This is the set copy of the diary, which has been already marked as Exhibit 14. The postmortem of the victim could not be held there, so the dead body was referred to FSM, Calcutta Medical College. Thereafter, the dead body was referred to the said medical college for postmortem with an application duly forwarded by the superintendent Tilchura Sodor Hospital. Accordingly, postmortem was held. This is the copy of the application marked at Exhibit 18. Marked at Exhibit 18 in this regard, a DO letter addressed to was issued from the Office of the Superintendent of Police, Hooghly. This is the copy of the said letter. The letter is marked as Exhibit 19. During investigation, I arrested Mohammed Shamim, did not abscond. Mohammed Mujahid Khan and Mohammed Chand from their respective houses. The aforesaid accused persons are present before this court and identified by the witness. I have recorded the statements under 161. I forwarded the three accused persons to the court of the learned ACJM Tandon on 31st of January with a prayer for police custody. The said prayer was considered and allowed. I had taken charge of the aforesaid three accused persons from the court and returned to the police station. I was also in search of Ghaji Khan, the brother of Mujahid Khan, and with Iftikhar, but they were absconding. Constable Sarkar returned from FSM Medical College and handed over some articles which I seized under a seizure list and signed by me. Again, I went to the house of Ghaji Khan to arrest him, but he was not present there. During police remand, I had recorded the statement of Shamim, Shahbaz, Chand and Mohammed Mujahideen under Section 161 CRPC. On the 1st of February, I examined the accused persons and went with the aforesaid persons to Khan Marriage Hall for recovery of weapons. While arrived at Khan Marriage Hall, at that time, relatives of the deceased, Javed Ali, and many people were present there. I opened the lock of Khan Marriage Hall. PC accused Mohammed Shamim and other told in presence of local PO of Teripara that on 27th of January, noon, at about 1 hour, they murdered Javed Ali, alias Jahid. According to the statement of Mohammed Shamim, one Bhojali with wooden bat about 15-inch length was recovered from the western side room, first floor of Khan Marriage Hall. This is the said Bhojali, which has already been marked as Exhibit 1. The said weapon was seized under a seizure list. This is the said seizure list as prepared and signed by me. The seizure list is marked as Exhibit 3/3. Mohammed Shamim also put his LTI in my presence. The LTI of Mohammed Shamim on the seizure list dated so-and-so is marked as Exhibit 3/4. According to the leading statement of accused Shahbaz Akram Mohammed Chand, he went to the middle room of the first floor of the said hall and recovered one sharp-cutting hasua, as shown by him and in presence by local people. I seized the same under a seizure list prepared and signed by me. The seizure list dated so-and-so is marked Exhibit 4/3. The accused Shahbaz also put his signature in my presence. The signature so is marked Exhibit 4/4. This is the said siege hasua, which has already been marked at Material Exhibit 2. According to the leading statement, Mujahid, Sahabaz, and Mohammed Shakir recovered one blood-stained lungi as shown by all the accused persons. So, 27 of 3 persons resulting in one lungi. And cannon board from the PO as shown by them. I seized the same under a seizure list and signed by me. This is the said seizure list dated 1st of February, marked as 5/3. The accused persons also put their respective signatures and LTI on the seizure list in my presence. Here are the said signatures in LID so-and-so. I have recorded the statement of the seizure list witness under so-and-so. On the 2nd of February, I received an information from my source that the rest FIR named accused person, Shagor, surrendered before the learned ACJM Chandan Nagar. I came to the court and submitted a prayer for PC of the aforesaid accused. The prayer was allied. I came to the police station with the PC accused and examined him. I recorded his statement under Section 161 of the CRPC. Photographer Taposh Bhattacharya had handed over 5 copies photo of the victim to me, which I had seized under a seizure list prepared by me. This is the said seizure list. The seizure list is marked as Exhibit 10/1. Taposh Bhattacharya also put his signature on it. The signature of Taposh Bhattacharya has already been marked as Exhibit 10. According to the leading statement of Iftikhar, I went to the house of Iftikhar along with force and recovered one sharp-cutting nepala from his bedroom under the bed as shown by Iftikhar. I seized the said weapon under seizure list. This is the said seizure list. The seizure list is marked Exhibit 6/3. PC accused Iftikhar also put his signature on it in my presence. The signature of Iftikhar is marked as Exhibit 6/4. This is the said siege Nepala. The Nepala has already been marked as Material Exhibit 5. The said iftikhar is present before this court, but the witness fails to identify the accused. The accused disclosed his name as Muhammad Shamim. I arrested the accused iftikhar about 3 years back, so I cannot identify him. I examined the Caesar list witnesses on 4th of February 2011 and recorded the statements under 161 CRPC. I recorded the statement of Shahib Bibi, Nazila Khatun, Fakhruddin and Dawood Hussain under section 161 CRPC. I also forwarded the aforesaid witnesses to the court of the learned ACJ for recording their statement under 164 of the Code of Criminal Procedure. On 8th of February, I myself, along with force, went to the house of Ghaji Khan to arrest him, but he was absconding. On 10th, I submitted a prayer for collection of the copy of the statement of the aforesaid witnesses. On 15th, I went to the house of Ghaji Khan to arrest, but he was absconding. On 25th of February, I received post-mortem report of Javed Ali Jahid through Constable so-and-so. I kept the same in my case diary. The post-mortem report has already been marked as Exhibit 8. On 1st of March 2011, I sent Constable Jagdish Chaudhary with the viscera of deceased Javed Ali through ACGM Chandanagar to the FSL Kolkata for obtaining forensic report. On 2nd of March, I sent one sealed packet blood, so-and-so, so-and-so. Well, I'm skipping these because these are which was said, and your lordship has seen the reports. Subsequently, I had collected forensic report. The forensic report had directly already been marked as Exhibit 15 series, which my lord has just had gone through. After completion of investigation, I filed charge sheet against the 5 accused persons. Mohammad Gaji was shown as absconder by charge sheet number so-and-so. I have filed an application to the learned ACGM for filing supplementary charge sheet after collection of the forensic report. For filing supplementary charge sheet, I again took up further investigation on 18th of August. During investigation, I had obtained viscera report of the victim from FSL Calcutta, 1 glass jar marked A, and forensic report from Dr. Chaudhary and so-and-so. Thereafter, consulting the above report, I have filed supplementary charge sheet being number 1, dated 10/1/12. Well, cross-examination will come tomorrow. I'll come tomorrow.
No, continue.
After 2.
Yes, yes. Where is the difficulty?
No, your lordship wanted Mr. Doctor to be present. That's why I thought.
No. That is a different case.
Well, then I'll come back at 2.
Yes, please continue. Yes, we can continue. Yes, come at 2.
Lord, other matter may be released. How long?
What?
Other matters may be released. How long, my lord?
I have a bitter experience while there and this side as well, because suddenly you don't know when the matter collapses. So it is better not to release any matter. Yes. Let him come.
Honest present.
No, no, AG.
Actually, when they are met him, one matter is Shahjahan or something that was going
Let us see. Let him come. I will come. I know. Yes.
Well, we were on the examination in chief of the investigating agency.
Yeah.
Well, page 81.
Yes. No, you have taken us to 86.
Up to the chief, my lord.
Yes. Cross-examination.
You will start now.
Yes.
General diary number so-and-so was lodged by one Nizamuddin, the father of the victim. There is no statement in the said diary that some person called the victim and went away. It is written in the said diary that the victim left his house. My lord, there's one thing which I just forgetting to tell your lordship. My lord has spoken about the last seen theory. Once we go to the last seen theory, then it becomes a question of circumstantial evidence. Now, once circumstantial evidence is to be proved, then the question of motive comes. Direct evidence, no motive required. But when it is circumstantial evidence, my lord, there has to be a motive behind the death of that person.
Suppose if the last seen theory is there and there is no reasonable explanation in this regard. I'm talking about section 106 of the Evidence Act, special knowledge.
106. Yes.
If it is not, then is it not that the same is proved? I'm talking about.
I'm grateful to your lordship for bringing in 106. I'm grateful. But what I'm
talking about the latest judgment of the Supreme Court on that basis.
Yes. You're right. That's right. The only thing, 106 comes into play after the prosecution
has established some kind of a link. Last seen theory has been proved without any, I think, any doubts in that regard.
In this case?
In that case.
In that case. Yes, my lord. 106. Now, I'll answer that also. I'll do a little bit of homework also.
If I correctly remember, my memory goes right. It was Justice Rohatgi's judgment. I think Ram Gopal is a judgment. 2023, volume 5, SSC, page 534.
I wish I had your memory.
Where there has been a drift, a shift, I would say, from
the normal
situations.
But in
favor of the prosecution. You have not brought the judgment. Now these younger generations have more gadgets with them.
No, I'll do it. I'll just find that. Now, let's start again. I did not go to the workplace of the victim to inquire whether he resumed in his workplace in the second half or not. I cannot remember whether on 30th at 3 a.m. Khan Marriage Hall was under lock and key or not. I did not seize the lock and key of the said marriage hall. On 30th of January 11, at about 3 a.m., many people were also present with us. At first, we all along with people went to the first floor of the said marriage hall. The PO was identified by the complainant and others. Well, how could a PO be identified? The hall can be identified that he was last seen going inside the hall. How could the PO be identified? Now, once we see the fallacy of their statement. PO, according to them, was the first floor. First floor, they did not find anything. Then they come to the second PO showing the septic tank.
Yes.
The PO was identified the complainant and others. I did not collect any dried up blood from the said room. I did not consider any incriminating article in the said room. I searched all other rooms. At the time of searching, along with us, neighbors of the said marriage hall, Para people and relatives of the victim were also present. I cannot say total number of the persons who were present at that time. On 30th of January, I did not seize any incriminating material from those rooms. I did not follow any incriminating articles on the first floor, but find any incriminating articles on the first floor at that time. The rooms were opened at the relevant time. I cannot remember. After searching of the room, I locked all the rooms or not. I did not go to the roof of the said hall on the same day. I did not search any room of the ground floor, but I found partly open septic tank and some blood. I did not collect the sample of the blood from the septic tank. At first, I have seen the dead body in the septic tank. With the help of Dome, police personnel, relatives of the victim and other people, the dead body was recovered from the said septic tank. The upper portion of the septic tank was opened for the recovery of the body. Right, Mark? Search list is to be prepared, whether articles were found or not. To arrest the accused person, I went to their houses, but they did not prepare any search list. I locked all the rooms and main door under lock and key. I cannot remember at the moment where I kept the keys. Then says it may be kept at town hall post at Ketelinipara. Specifically, no guard was posted at the said marriage hall. I did not label the weapons and the lungi at the time of seizure. I cannot say whether there is any Bart or Nepola or not. I have visited several times at Khan Marriage Hall during my investigation. The said hall is a reputed one in the locality. Muslim community use the said hall for their ceremonies on rent. I did not investigate whether there was any guard in the said marriage hall or not. I did not investigate whether there was any worker in the said marriage hall or not. There are 10 to 12 shops adjacent to the said marriage hall, none examined, excepting PW7, who had a beetle nut shop opposite. Not a fact, so and so. There is a passage adjacent to the boundary wall of the Khan marriage hall. I have not seen any tin-made gate in the back portion of the marriage hall. I do not know whether there is a tea stall which is open for 24 hours adjacent to the marriage hall or not. I did not examine any shop owner of the marriage hall excepting 5.
Adjacent shop owner.
The 10 to 12 adjacent shops, out of that PW5 is one of the owners of the shop. We contacted with the relatives after receiving the said missing diary.
We did not take any help of
the sniffer dog, PW3. The accused persons were not present when the dead body was recovered. The owner of the said marriage hall is residing outside. Mujahid was present at the time of locking the door. I did not seize the said marriage hall. On 30th of January, I did not consider to search all the portions of the said marriage hall. On 30th of January, I did not visit the ground floor at first. There is no house in front of the victim house. Very important, my lord. I did not see any attendance register of the victim from his workplace. But why I'm saying this is important, but if a lordship comes to the mother statement, PW2,
that she could not go there for the work.
No, I'm saying about, she says 8 to 10 cubits is the Khan marriage hall. That is what I'm trying to show to you, lordship. Well, it starts at page 25. Well, first, page 25, first line.
Opposite to our house.
Yes. 15 to 20 cubits. Then, well, let's get back. Well, I'll give the descriptions of the witnesses after I finish this, because I was trying to minimize your lordship's pressure on this matter, my lord. So I tried to do it in that.
Yes.
We contacted with the relatives after receiving the said missing diary. We did not take the help of sniffer dog. The accused persons were not present when the dead body was recovered, the owner so and so. On 30th of January, I did not consider to search all the portion of the said marriage hall. On 30th, I did not visit the ground floor at first. There is no house in front of the victim house. I did not seize any register of the victim from his workplace to court. For the purpose of investigation, I have no need of the marriage hall. I have no objection if the possession of the marriage hall is returned to the owner. I don't know why relevant. Why relevant? I won't know.
Because everything is over.
Over. Investigation is complete. Conviction is done. There's no harm in giving it back to the owner. Now, Malat, resume today. On 30th of January, I, along with officers, searched the first floor of the said marriage hall. There is no mention in my case diary what steps I have taken to ascertain the PO. I did not find any clot of blood, drops of blood, or marks of blood in the said room. I did not find any clot of blood, drops of blood, and marks of blood in other rooms. Khan Marriage Hall is a 3-storied building and there is a staircase. I did not find any blood in the staircase or marks of dragging, as the same was washed by water. Reason how he came to know that it was washed by water would mean, my lord, I wouldn't know how he said that, because this is happening on the 30th itself. There is no mention in my case diary that the staircase was washed away. I did not find any maggots on the dead body. The head and body was sent for postmortem. I did not mention the color of the lungi which was seized on 1st of February. The seized lungi, item down 1 of the seizure list, was sent to FSL for its chemical report. I did not measure the length and breadth of the hasua, was seized at by so-and-so, then says the measurement of the said room is 16 into 16. It is not mentioned in my case diary where the hasua was lying specifically in the said room. It is also not mentioned in the case diary what kind of article furniture was also in the said room. The same type of hasua is also available in the open market. There is no specific mark or identification on the hasua excepting the mark of label. The dead body was recovered on 30th of January 2011. Hasua was recovered on 1st, lungi 1st, bojali 1st. I did not investigate the condition and situation of the said Khan Marriage Hall from 27th to 30th till recovery of the dead body. Malad, your lordship pointed out to me, it was open. No functions may not have been done. The hall was open. Mujahid was there in the hall on 28th and 29th. I did not request the magistrate to accompany with us for the recovery of those articles. Not a fact that the murder was not committed in the middle room of the first floor. Not a fact that the beheaded dead body was kept in the septic tank after committing murder at the outside. Inquest held by me over the dead body. It is not mentioned in my case diary whether it was done or not when the victim was alive. Not a fact that the dead body was not the dead body of Javed. I did not record the statement of Muhammad Rijaullah. I also did not examine the dome. I cannot say where the complaint was written. After perusing the statement under section 161 and 164 of the CRPC, I have filed charge sheet. I cannot say the exact time when Iftikhar was surrendered before the court of learned ACGM Tandon. On 2nd of February, I filed an application to the court of learned ACGM with a prayer of PC for Iftikhar alias Shagor. The said petition was forwarded by the officer in charge of Bhadrashwar Police Station and the Circle Inspector of Chandanagar PS. There is no mention of time in the said forwarding report. I did not mention in my petition the time when it was filed to the court of the learned ACGM Chandanagar. In my petition, it was written, during investigation, I came to learn that FIR named so-and-so surrendered on learned court on 2nd. Offending whoever's recovery is urgently needed from the accused, which he kept connected in an unknown place prior to production. There is no mention in my case diary when I had taken charge of the accused Shagor. Then says I had taken charge of Shagor from court custody at 4:45 hours on 2nd of February. Well, it should have been PM. 4:45 PM.
Can't be.
Early morning, 4:45. On 4th of January, I left police station at 10:05. I reached in the house of Shagor at 11:05. It is not mentioned in my case diary between 10:05 to 11:05 where I went. I did not mention the description and surrounding of the house of Shagor. I did not examine the family members of Shagor or obtain their signatures in the Caesar list dated 4th of February 2011. Before entering into the house of Shagor, we did not search ourselves by any independent person. I also did not examine the neighbors of Shagor. I did not send the cover of weapon, which was seized on so-and-so, to the forensic laboratory for examining of the fingerprints. Apart from Nepala and cover, I did not seize any article from the said room. Not a fact that I did not enter into the house of Shagor and I did not seize any Nepala and its cover as per Caesar list dated 4/2/11. Not a fact that I did not investigate property. Not a fact that I falsely implicated Shagor in this case. PW1 did not say to me that when I came out, I saw Chand and Shagor was standing outside in front of our door. PW1 did not state to me that I stated to the police after 2 days, police came to our house with Shagor. PW2 did not state to me that I stated to the police that Shamim came when Javed was taking his meal and Chand and Shagor was standing outside our door. Not a fact that I made out a false story of Nepala and implicated Shagor falsely in this case. I cannot say the distance between Gonga and the police station, then Malat Bhadreshwar and the outpost. Now, PW6 did not say to me that I stated to the police that Nepala was taken out by Shagor from under the bed. I received the written complaint at 3:45 hours on 30th of January, and the police station received the same at 4:15 hours. In the formal FIR column, time is written as 4:15 hours. The investigation was started after receiving the written complaint, that is not before 3:45. After perusing the written complaint, I entered into the Khan marriage hall. After receiving of the missing daddy, I entered into the Khan marriage hall. The dead body was recovered at 3:15 a.m. The dead body was found before receiving of the written complaint.
Yes.
Before receiving of the written complaint. In the written complaint, there was no whisper from where the dead body was found. There was no note in my CD how many dogs were engaged for the lifting the dead body from the septic tank. For the purpose of removing the dead body, the septic tank was not broken. I did not interrogate accused Shagor before taking him in my custody. Before taking the custody of the accused, I was sure that there was a chance of recovery of offending weapons from him. I had taken police custody of accused Shamim, Chand, and Mujahid also. I went to Khan marriage hall with the above 3 persons. I did not obtain signatures of Shamim, Chand, and Muhammad Shagor in each Caesar list. There may be some space in the water tank, besides the water tank and under the water tank. In the last portion of the Caesar list, where the lungi and carom board were seized, as shown by the accused Mujahid, Muhammad Shamim, and Muhammad Chand, but I've written inadvertently only 2 names, Mujahid Khan and Muhammad Shamim, in the last portion of the said Caesar list. PW 3 not stated to me that he was standing in front of Khan marriage hall on the road. PW 11 not stated to me that he asked Mujahid Khan to know about Javed. PW 6 stated to me that in the night he woke after hearing a hue and cry at so-and-so, and thereafter he left the bed. Not a fact that it is case properly. So the investigating agency, now Malat, if a lordship please comes, Malat, as your lordship knows, what we had learned when we started practice was a very important piece of document is 330. Because the circumstances which are against me have to be put to me in my 313 examination. So that is a very important piece. Now, Malat, if a lordship sees, may I say one thing here?
That is what that judgment says. If you remain silent and did not disclose anything,
nothing will happen.
Then 106. That is what I say. There is a chance.
In 313?
Yes, it was that if you remain silent, something which is within your special knowledge, if you do not divulge, do not give an explanation, then you can be.
Let's just for Malat argument.
That's why I told you that judgment.
No, I'll find
a little
off the track, off the track
from the
other laws, other judgments. No, may I say this, Malat?
I think the state cited in one of the case. You cited that judgment in other case.
देखिए अच्छा
You
तुम
forgot.
এনেছো
Look at it. That is what is. Have you got?
देखिए judgment
It's tallies.
yes paragraph 6 7 and 10
I do not.
একবার দেখি না একবার দেখি
Page number tallies.
my lord one in our favor
Yes.
one in our favor my lord has to be said also balance has to remain my lord
Page number, if I correctly remember,
543.
354. If I correctly remember.
কত লিখলি my lord লিখলে কত লিখেছি তো I think 543 your lordship said
No, 354. If I correctly remember. Ram Gopal.
Yes.
2023.
Yes, but he got it.
SCC.
Hon'ble versus state of
Correct. So, page 2023, volume 5.
volume 5 আর দিয়ে না এখানে দেখি না
353 or 354, if I correctly remember.
আমি না এগুলো তো তোমার এগুলো রিফার্ড হচ্ছে এইগুলো হচ্ছে তোমার সাবজেক্ট হ্যাঁ মানে the lordship is speaking about 106 okay. What is there not
What is the page number?
Page number is not there. Their own evidence. ওইটা দেখছি ওইটা মানে it's 534
550?
534
534.
Oh,
yes. 534. I was close.
no, your lordship said 543.
Oh.
My entry is 543. একবার দেখিনি
By Justice Rastogi?
No, only one and only Bela Trivedi. Bela Trivedi.
And Justice Rastogi or
Ajay Rastogi.
That's why.
No, Ajay Rastogi is the A of Justice Tandon Singh Alwar.
I know everything.
Sometimes
I attended.
I also attended, my lord, Chandigarh. Well, he was the Chief Justice of well, here the basic factually it's different.
But I said that there are.
No. What happened here, my lord? 19th of December 95.
I was
last
talking about 106 because 313. The normal, the usual, the law is that the accused would remain silent.
Can remain silent.
He will not diverse. He will simply say he's not supposed to. But I think there has been a.
Well, here there is no 313. No 313 part. No 313 part here.
106 says the explanation where it will come. Only possible avenue of the accused giving an explanation is 313. There is no other provision. If I correctly remember, it was 6 or 7 months before. So I remember that.
Okay, my lord, I'll find an answer to it. Well, I'll get an answer to this. Because 106.
Something which troubles me after reading that. That's why I said that.
Thanks, so that I can answer that.
Yes, because that is in his favor.
Well, I'll show. Well, I'll try to impress upon your lordship that 106 comes into play after the prosecution has taken steps to prove its case. Well, let us understand. What is special knowledge? That I'm aware when the body was there. I did not recover the body.
Special knowledge means.
My lord, Pakala Narayan's case was a case we were taught in college.
Yes.
About 106. A ticket collector comes to me, asks me to give a ticket. I could not produce that ticket. And buying a ticket was specially within my knowledge. That is how 106 came into force. That is what I learned well.
That is what I said at the very outset, that there has been a
deviation.
Great deviation and, may I say, diversion in that.
Yes.
Because it has really drifted from a normal rule to something else. That's why I said, at the very outset, I said.
No, your lordship told me that.
So you'll have to answer that, because the 106, what we know in a civil consequences also. Mostly 106 are applied when there is a matrimonial dispute between a husband and a wife and the husband is concealing his income. So 106 says that the income is within the special knowledge of the husband. If he concealed it, then it will go against him and adverse inference can be drawn. That is what we groomed.
But after this judgment, your lordship is thinking anew. Thinking anew.
How we groomed.
Yes, well,
So now
that is what I told your lordship.
Something which is within. Now 113. 313. Normal rule is that whenever 313, the accused is allowed to keep silence or say, I am not guilty. He is not able. But this judgment says that if you remain silent and something which appears that within your special knowledge, then it can go against you.
Is your lordship contemplating that the special knowledge is that they were last seen together with me?
It is what is the case.
That is not the case here.
No, this is what is the case.
That is not the case here. That is within 24 hours, the body was found. Within 20, paragraph 6.
No, it's a paragraph 5 and 6 is a very important one.
Yes, my lord. I've gone through it.
It cannot be gainsaid that when the entire case of the prosecution hinges on the circumstantial evidence, which is the case here, the entire chain of circumstances has to be completely proved, which is a very
unerringly proved to the guilt of the accused.
Unerringly would lead to a guilt of the accused and none else. Then it says, so far as the evidence on record in the present case is concerned, it emerges that it was not disputed that on 9/12/1995 at 5 p.m., the petitioner accused has taken the deceased Pratap Singh from his house.
Correct.
What is it? Thereafter, the deceased and the petitioners were also seen together at the shop of one Sripal at village such and such by a witness. Here also, Bittle shop owner.
No, only those are the same place.
It was also not disputed that on next day morning, the dead body of the deceased was found lying near the one field. Hence, the death of the accused has taken place during the night hours of
19th and 20th. 19th and 20th.
And that the petitioner was lastly seen with the deceased on the previous evening. Thus, it can be a petitioner alone who now is who knew as to what happened after the evening of 1912. Then says, it may be noted that once the theory of last seen together was established by the prosecution, the accused was expected to offer some explanation as to when and under what circumstances he had parted the company of the deceased. It is true that the burden of proof the guilt of the accused is always on the prosecution. However, in view of Section 106 of the Evidence Act, when any fact is within the knowledge of any person, the burden of proving that fact is upon him. Of course, Section 106 is certainly not intended to relieve the prosecution of its duty to prove the guilt of the accused. Nonetheless, it is the equally versatile legal procedure that if the accused does not throw any light upon the facts which was proved to be within his special knowledge, in view of Section 106 of the Evidence Act, such failure on the part of the accused may be used against the accused, as he may provide an additional link in the chain of circumstances required to be proved against him. This is what I really wanted to. No, it was he was there. Dispute that all such as a.
One of the facts are not similar.
The evidence that all
facts of our case is not at all similar with this case.
Has taken the
This is, it is here also. He can instrument and all that.
দাঁড়ান না বার করবো তো Well, what I'm trying to say, my lord, each case is decided on its own fact.
Oh, I have delivered many judgments on
No. Please, my lord. Your lordship is senior number 4 here.
Each facts may give rise to a particular decision. A little variation or an additional fact may invite a diametrically opposite decision. So
I'm with your lordship. One has to say whether this is applicable in our case or not. That I will prove, your
I
lordship.
was on a principle of law.
No,
whether it
principle of law
applies
of
or it does not
106. Well, your lordship is on the principle of law. The onus shifts on me to prove that that man was not with me. If I've got your lordship.
No, so far as the Mujahideen is concerned, your client.
Yes.
He was found standing at the entrance of the
marriage.
And the vittle shop owner has said, we have seen that.
And the mother has seen it.
Yes,
Both mother and the.
And you welcomed him inside.
Yeah.
Now the question is, entering into the hall is undisputed that he entered. Disputed means you will definitely dispute it was not. But I say that it appears that this appears to be that the chain of events entering. And secondly, thereafter, he was not seen by any other person for 3 days. And ultimately, the body was recovered from that marriage. Now, if that being the position, then entering, if it is there, and the prosecution has been able to prove that he entered into a marriage hall, and corroborated by one fact that his body was found from that marriage hall. So the entry into the marriage hall appears to be undisputed at this stage.
No, my lord, it is disputed. I'll tell lordship why.
The body was found there.
No, I'll tell you why, my lord. The GD entry, which was of the missing of the person, they did not speak of V4.
Whatever, but ultimately,
So,
the evidence
disputed.
The evidence comes.
What is the evidence?
That yes, it was he entered. He was carried and he entered because into that, and the body was found. If we link these two, what is the correlation?
Well, the body was found after 4 days.
Body
after 4 days.
Now, your
yeah,
case is,
the body was found next day morning, and he was seen again.
Your case is that body may be implanted there. Some from somewhere it can be brought there. It does not mean that entry has any relation with the
dead body,
recovery
of the dead body,
the discovery of the corpus.
Yes, right, my lord.
Corpse.
Yes, my lord.
You can say that is your case. I understand.
My case is different from this judgment of yours, my lord. Is in this way, my lord. My lord, my case starts from the first is the inordinate delay in for lodging. No, I'll tell lordship one by one, my lord. Because my lord, your lordship has confused me. I haven't seen the judgment.
No.
So I'm a little confused.
Why you are confused?
Man, I not level of your lordship's intelligence.
No.
I am a small criminal lawyer, my lord.
What are you talking about?
No, man.
If Mr. Mukherjee says that he's a small fry, I do not agree. I think nobody on the
everyone will agree.
Present will say that he's a small.
No, I tell lordship.
My brother by this time will not agree. No, my brother is correct. This is another disputed fact.
Well said. I'll answer that one. I'll answer that. Well, let me go through the judgment.
Now you complete it. Just keep it in your mind.
Yes.
What troubles our mind? Please.
Your lordship, I've known your lordship's mind. I have to.
Yes.
Now, my lord, please comes to. My lord, I have made a small.
13. You were taking us to
330. My lord, please comes. My lord.
Page 94.
Yes. Here. Judge. My lord, comes to question 5.
Yes.
Then question 6. These are the things where they say that
Yes.
Then, my lord, দাঁড়াও একটা করে আমি তোমার মতন ইন্টেলিজেন্ট না টাইম লাগবে my lord, has the lordship seen it, my lord? My lord, I've got nothing to do with the Bhojali. Then my lord comes to, now come to 22, my lord, at 97. Question number 22.
Question number?
22, my lord. 3 witnesses have said PW1, 4 and 7. At page, my lord, previous page, your lordship gets it at 80.
No. Which one? 22 you said then?
Yes, no, prior to that one where it starts is at page 96, question number 18.
Yes.
So-and-so stated that accused Shamim Chand and you went to the upper stairs with them, another witness, and Shamim brought out a dagger, Bhojali from one room there, and he delivered to the police in their presence. What is your say? Now, my lord, it's nothing to do with me.
No, I understand.
Now, my lord, please see. Now, brought one Hasua, Chand, then my lord comes to 22.
Yes.
Above-mentioned witness further said that you, Mujahid Khan, recovered one bloodstained lungi from the water tank in presence of witnesses and hand over the same to the police. What is your say false? Now, my lord. Then also, my lord, Shagor has nothing to do. Then, my lord, what your lordship says, 26.
22 is because if it was recovered on the statement which
of 27 of mine, the lungi part.
So, but you say false.
Yes. Now, then comes on 26.
Yes. Simply say, I do not know it is false. I do not know it is false.
That's one no specific statement made by him. What is his defense? That was never stated as such as your lordship has said. But the fact remains, my lord, if your lordship goes through the entire thing, my lord, your lordship will see that the Mujahid part only, my lord, question 53. Question 53 at 101. Witnesses.
A simple way of denying. He has simply denied whatever has.
So that my lord, I just give a short note I have prepared. My lord. I'll just tell your lordship, my lord, if your lordship wants me, I can short notes of the role of the.
Sure.
I made it, my lord. Only thing, my lord, the judgments I will bring then tomorrow and I'll do the judgments. Give it to your lordships.
I also do it when I dictate. PW1, what he has said. PW2,
Yes, sir,
what he has said. PW3, what he has said. PW4.
Then I've done it that way, man. এটা ওটা দিয়ে দিই তবে তুমি বলো আমি জাজমেন্ট করে দিয়ে দিই মাই লর্ড এটা তো আনসার করতে আমার ঘুম চলে যাবে রাইট হ্যাঁ Well, just see, well, I just give it to you, but I hope you can read my handwriting. Just then, well, I'll have it done in this way. Or make it more specific, my lord.
No, whatever you want, if you want.
Okay. At the now.
We'll definitely.
Right. So, my lord, wait, copy for me. Postpone. Well, can it be on Wednesday, my lord? Let me get ready with that, my lord.
No, you complete it and then.
More or less, I've completed my part.
Any judgment you want to say?
No, I've not brought it. That is why, my lord. Oh, Brihaspativar, hearing day. Well, then Thursday, I gather that's the hearing day. I'll just take another half an hour.
There
with
are other
people will.
Other.
My landed senior friend, my lord, all my argument also, my lord. 1 or 2 point, my lord, I have. I am for the.
Who are you? First, let us understand.
I am for the criminal appeal number 85 of.
Yes, your name has been disclosed that you accompany him.
Okay, so take it easily too.
He was standing on a entrance door of the car, the
Where I work.
But your evidence is against you is that you came and then called him and then took him.
At the time of taking it, my lord, others also accompanied me, my lord.
No, true. So if you have taken along with the others, say that. We'll consider. So you have virtually completed.
And my lord, I am giving a written note to Bargon, my lord, that I have prepared for myself.
Well, only 6 interact with 659.
What about the other?
But the other, my lord, he is.
You are for Samim.
Yeah, I am for the Samim, my lord. I am for
Samim.
legal service.
So your 313 is one and the same.
Same.
Yes, ma'am. Same.
Yes.
All same.
Don't know, false.
Don't know.
Came later on. Came to know later on. Nothing to say.
No alibi, no explanation.
Oh.
No alibi, no explanation.
Oh.
The worst thing is alibi. Taking an alibi is a very, very risky proposition.
So nothing. So
no, my lord, in respect of the other one, my lord, my lord, he just got a phone call. His father is ill. He just rushed. So, my lord, Rakib, who's in 659, he was there with me just now.
He was for Mohammed Chan.
Mohammed Chan.
There are how many?
Three appeals.
Who is assisting him or?
No, he's a junior, my lord. He was doing it junior himself. But for the purpose, I have done it. But to answer questions, my lord, I will any day which suits your lordship. Apart from 8th to 12th.
Because of that, if they are, my lord, we are much more relief that
What?
Landed senior is there, my lord. We are much more relief, my lord. That's why, my lord, he is also relief, my lord.
But he's not liking that.
My lord.
But he's not liking that.
My lord. But I am for the High Court legal aid service, my lord. This client is not. I'm
Thursday, if it is convenient to your lordships.
Yes, Thursday, then come.
Next Thursday.
Since my lord, this point your lordship has said all. I'll come up with only one additional point. My lord, so far the minor discrepancies, my landed friend tried to point. So that will be the other. One point of that minor discrepancies doesn't vitiate the my lord.
I do not know whether he will take advantage of 2018 volume 6 SCC or not.
Thank you for another in our favor, my lord. Well, when Lord does your lordship get the time? Because after April, my lord will be number 3. Your lordship more busy.
More busy.
More busy, my lord.
What we used to do when I was there at night. So that
habit is there.
2018?
6.
No, I tell you very frankly, because I never practiced on this branch of the law. But after my departure from that side of the room to this side of the room, I find wonderful the branch. And if you have a jill to learn, there is no difficulty in learning. So I regret now that why I did
not do it at that time. Because, my lord, we are only famous for
also.
Never first time. My lord, what happens is, my lord, we are only known for bails. Nobody thinks that appeals is a part and parcel and a tough thing to do. For criminal, it would be only bails. Nothing more, nothing less. Well, I did, Dr. My Lord. My Lord, give us the date.
It's a really a learning. I just try to.
No, I'm seeing your lordships.
No, I just
Latest position of law, my Lord, which.
That's an interest that I develop.
Yes, so far, my lord, we all know, my lord, starting from my lord civil side to this side, my lord. Yeah.
So
My lord, latest judgments, my lord, collections before you.
Sorry. And that even in your lordship memory. No khata to find out which judgment, my Lord.
Yes, thank you. Let this matter be listed on Thursday. Thursday, no, Thursday.
Thursday. Eighth, my lord.
It's an assignment.
So no, eighth.
Thursday.
Eighth Friday.
No, Thursday is the 7th.
Seventh. Grateful, man. কি হলো অনন্যা? অনন্যা কি হলো?
Yes, call.
11, my lord, I beg to appear for the appellant. My lord, on the last occasion, my lord directed me to produce the original exhibit. My appeal was dismissed for continuous default, my lord. Hey, this is the original, my lord. This is the. I have prepared a typed copy, my lord. But I have prepared a typed copy for my lord.
Let's see whether it.
Yes. Yes, my lord.
It's not the only document. There are other exhibits as well.
There are other exhibits, my lord,
There are
but
those
the
exhibits.
problem is with regard to this. I have only taken.
Problem is not with regard to this. Problem is that every exhibit should be brought back.
But I have only obtained these documents, my
No.
lord. I tell your lordship,
You'll have
there
to
is
see to it.
3 to 4 documents, my lord. One gift deed and another is a partition deed. My lord, I have not got the original of this gift deed and the partition deed. My lord, I have,
Oh, those were marked exhibit. What are you talking about?
but that has been submitted before the trial court. But I have only,
You have returned it. You have taken
I
it
have
back.
only taken it back. These
Yeah.
documents, my lord.
Only
This
this
is
document.
only
No other
these
document.
documents. No other. So
What
far,
other
to my instruction, my lord, I have only get these documents, my lord.
Right. This is the letter. The question was that petition to get documents returned back with a specific undertaking. No further. Also, documents are returned to the printed. They are sealed, acknowledged. Today only we obtain the certificate copy and the quantity required. It's just nothing. This is perfectly justified. Yes. How? In all such stuff. Proceeded to have a legal. See what he is. Pursuant to the order dated 26/2/2024, the appellant produces a deed of that's it. Let's see. So,
This is a final decree and the deed of, this is a sale certificate.
This is the sale certificate, my lord. That is,
What about the first? Exhibit 9, there are two documents.
I tell your lordship. This is the sale certificate. Where, my lord?
This is the second one is a sale certificate. What about
can
the
you-
first? Exhibit 9?
Can you give me a time, my lord?
It's a final decree.
Yes.
Dakaldevar Adesh.
Well, that is the
Relating to
proceedings in
execution.
title execution case number 43 of 1959. But I not has document the exhibit 9. I don't have the copy.
Tell you, you have been handed over this copy, you did not care to see that, what this copy is. There are two exhibits which you have.
Yes, my lord.
One, this document, which is exhibit 9.
Yes, my lord.
Exhibit 10.
This is the exhibit 10, my lord.
So, I'm talking what about exhibit 9? Exhibit 10 is a sale certificate, I can
Yes.
understand. Certificate for sale of it.
Yes, my lord.
And what about the exhibit? Where are rent receipts?
That my clients has not handed over me the
Pursuant to the order dated 26/2/2024, the counsel for the appellant hands over the exhibit 9 and 10 before this to this court. According now, it appears from the impugned order that several documents which were received in evidence and marked exhibits were taken back by the appellant with an undertaking that the same shall be refiled as and when so directed. According to the learned counsel for the appellant, exhibit 9 and 10, which are produced today, were taken back from the trial court and not other documents. In view of the contradiction perceived on a conjoint perusal of the order passed by the first appellate court and the statement and the submissions made by the appellant before us, we feel that the record pertaining to title suit number
arising out of my lord title suit number 53 of 2006.
title suit number 53 of 2006, which was disposed of by a judgment and decree of 30th September 2010 by the third court of civil judge, junior division, Baripur. We therefore direct the Registrar General to make a communication with the district judge, South 24 Pagnas, to ensure that the record pertaining to the said title suit is sent to this court on or before the next date of listing. Let this matter be listed March
18th March, my lord.
Take back and keep it with you.
My lord.
We want on the next day.
My lord.
Be document.
But I beg to appear on behalf of the appellant.
for the cases. Literally what you want to explain. Give the date we saw the date. Yes.
My lord, I beg to appear on behalf of the plaintiff appellant on the judgment of affirmance on the last occasion I placed before your lordship. My suit was dismissed, holding that I have no share, right, title, and interest in the property. Although I have purchased the property of my lord, one of the legal heirs of Kanhailal Noskar. If my lord may kindly turns to page 2 of the order of the appellate court. The genealogical table has been given there. My original owner was Kanhailal. Kanhailal, kindly come to page 2. Of the order of the appeal court.
You would not get a privilege of reading this.
But I have filed an application under order 41 rule 27 to bring on record, my lord, I tell you, lordship, in short. My lord, original owner was Kanhailal Noskar. Kanhailal Noskar died leaving behind wife Dhirubala and two sons, Nabukumar and Sudhanno, and one daughter, Bhanumati. Well, after the demise of Kanhailal Noskar, Nabukumar, one son, two sons, and the widow sold the entire property to Bechuram Mondol in the year 1963. In the year 1968, from Bechuram, Nabukumar Noskar purchased the entire property. But in that deed of sale in the year 1963, Bhanumati did not execute any sale in favor of Bechuram.
Dispute whether there was any Bhanumati.
Yes. Now
there was no Bhanumati.
Now I filed an application under order 41 rule 27 demonstrating before your lordship that Bhanumati, during the pendency of the suit in the year 2008, executed a deed of gift in favor of the plaintiff, that is Gautam Noskar, son of Sudhanno. But the court held that I have no right, title, or interest over the property.
Because there is no existence of Bhanumati.
No, Bhanumati was made a party.
She did not come forward and contested it.
No, Bhanumati was defendant number 2. But he did not file a written statement. Now, so far as the finding of the court concerned, but so far as the two deeds are concerned, whereby the three legal heirs, that Dhirubala, Nabakumar, and Sudhanno, executed a sale deed in favor of the Bechuram Mondol, and subsequently when Nabakumar purchased the entire from Bechuram Mondol, my lord, the Bechuram Mondol came in the witness box. He said that neither I have purchased nor I have sold. Now I took out an application in the nature of section 45 of the Evidence Act for appointing the handwriting expert, but in the appellate court, read with order 26 rule 10A. That application was rejected on the ground that it is a 30 years old document, presumptive value is genuine, but that presumption is rebuttable under section 4 of the Evidence Act. Now, in the order 41 rule 27,
not apply before the trial court.
No, I did not apply. I cannot improve my case by making an argument before your lordship. But kindly see the application under order 41 rule 27.
Not required. If the Bechura, whatever.
Yes. Bechuram Mondol,
He said, I never purchased, I never sold. The fact remains that the Novakumar remained.
Novakumar remains, and all the legal heirs will have to have 1/4 share. All the legal heirs on down to the line succession will have their respective shares.
There are two things. One is Kanailal Noskor.
Yes.
Kanailal Noskor has he sold the property to Bechura?
No, Kanailal Noskor did not sell.
So after his death, the widow, Novo, another son, and
Sudhanno,
Sudhanno.
the Novakumar and Dhirubala.
Forget about Bhanumat.
My lord.
Let us there. Now all these three persons, they sold it to Bechura.
Bechuram.
Bechuram in turn sold it to Novo.
Yes.
So at least Sudhanno cannot say. Now you say that Bechuram came and said, I do not know, neither I purchased nor I sold.
Bechuram said that neither I have purchased.
Registered documents are forthcoming. The document by which Novakumar purchased, those were confronted to him.
Yes.
What he says?
My lord, he says that kindly see the evidence, my lord.
Has he disputed anything? He did not.
Yes, my lord, may kindly see the evidence. I have handed over to your lordship.
Bechuram, what he said?
My lord, may kindly see the evidence of Bechuram.
On that, when he was shown the copy of the.
Yes. My lord has the copy of the evidence on the last occasion. I handed over to your lordship. Kindly see the cross-examination.
Not cross-examination. Me.
No, the second line of the
Bechuram's.
Yes, this is the evidence.
PW.
My lord, you will PW2.
PW2.
Copy আছে Xerox? বেচুরামের এক্সট্রা কপি আছে দেখুন। আমার কাছে তো অরিজিনালটা রয়েছে। May I just hand over? There are one copy on that. Kindly see, my lord.
No, I do not have PW2. PW3.
My lord, PW2 I have given, my lord. I'm seeing আরেকটা extra আছে। দেখি এটা আছে।
Where is the examination in chief?
My lord, this is the original certified copy.
I am asking you.
My lord, this is the chief. This is the chief, my lord.
Where is the chief?
My lord, this is the chief.
I wanted a chief. This is the chief.
Yes, this is examination in chief. চিফের কপি আছে? কপি আছে চিফের? My lord, may kindly see the cross-examination. First paragraph, my lord, third paragraph of the cross. May I read out?
Huh? You are Gautam Noshkar.
Yes, I am the plaintiff PW1 Gautam Noshkar.
He is a defendant.
Bechuram.
They are the defendant.
Yes, yes.
And you are claiming on the strength of the title from Bhanumati.
Mane independent of that.
Independence. So that
Apart from Bhanumati.
The second son.
Yes. I say that my father, nor my grandmother.
Whatever I got you.
But that apart, I have purchased with that portion from Bhanumati. But total land is of 8 kathas. Record of rights.
Yes.
So far as the portion of the purchase of Bhanumati share is concerned to the extent of 2 kathas, but I have taken out an application order 41 rule 27. But that application I ought to have taken in the before the first appellate court. But the whatever it might be, my lord, there might be a no proper guidance has been given, or I have not been informed.
What is the
shoot for partition?
For
partition.
That's all.
My lord, may I kindly take the order 41 rule 27? The deed I have annexed. The portion of Bhanumati to the extent of 1/4 share.
Very simple. They disclose those facts in the written statement that after the death of Kanaila, all the 3 heirs, they sold their property to the Bechura, disclosed the deeds, and then Bechuram in turn sold it later on to Navakumar. That was disclosed.
Yes.
Why you have not amended the plaint and sought for a cancellation of those deeds as well? Did not. And it was well within your knowledge that it is a forged document. It is a document obtained from misrepresentation, obtained for some other reasons. Then the period of limitation is 3 years. Now, at the appellate stage, just for the purpose of verifying or the, I think, the authenticity of the signature, what it would yield, because you have not prayed for anything. Then the court has to arrive that this deed is a forged one, does not contain the signature of this. Then you have to ask for a relief. If you have not, can you do it?
But that is my.
You are a plaintiff.
Yes, my lord.
You are not a defendant. Had you been a defendant, the position is different. I can understand. But you being the plaintiff, you have not asked for. And this was disclosed in the written statement way back.
But that is the worst case in my favor, what has fallen from your lordship. I tell your lordship, but independent of that, Bhanumati has never sold his share.
Now, question is, have you been able to?
What they could have sold, my lord, 1/4 of their share.
I understand, sir. You are taking a dip. Have you been able to prove that Hanumati was the daughter of Kanai?
But there is no dispute to that effect.
There is shall tell us that there is an admission.
But there is, so far as the Bhanumati not being a daughter, that is not being disputed because he has been implemented as a defendant number 2.
That you have implemented, they are not. Who is a dominus litis? The plaintiff.
But so far as
you may chose to implead 50 persons, but the defendant may come and assert in a partition suit that I have got an absolute right. Can he not?
Written statement again.
Yeah, you have impleaded somebody. You have to prove that she was a daughter. Have they admitted that she was a daughter?
My lord, so far as the plaintiff's witness is concerned, my lord, may I just take your lordship to that extent?
Tell us that the Bhanuvati was a daughter. No doubt about it. We will admit here and now.
Written statement again. W statement. W statement. My lord, so far as the share of Bhanumati is concerned, my lord, there is no denial that Bhanumati is not the daughter of Kanai Lal. There is no denial in the WS, my lord.
Where you have said and where they have not denied. Where you have said and where not denied. I just wanted to know that. I understand. So far as the Bichuram theory or the the story is concerned, we are not convinced. And Bichuram appears to be absolutely tutored because he has said something and then came and improved something more. He said that I never executed any deed in favor of Logo. He never said that I did not purchase those property. But in cross-examination, he says neither purchased nor not. I know. Nothing.
May I just.
Sorry.
May I just indicate your lordship, my lord? What is plaintiff? Plaintiff বলেছে। My lord, may I kindly take the plaint once? In the plaint, my lord, I have stated.
The plaint.
What is the plaint?
And where is the written statement?
My lord, the written statement and the plaint is here. My lord, may I kindly see the names of the defendants. The defendant number 2 is Bhanumati Koyal, wife of late Vibhuti Bhushan Koyal. My lord, he has been implemented as a defendant in the suit. Kindly see paragraph 3. That said Kanailal Noskar died on 20th October 1962, leaving behind his surviving years wife Dhirubala, since deceased, 2 sons, Nabokumar, Sudhanno, since deceased, and 1 daughter, Bhanumati Koyal. But that was not been denied in the written statement. Paragraph 2 and 3 has been stated as matter of records. Kindly see, my lord. Paragraph 3 of the plaint corresponding to paragraph 7 of the written statement.
What has happened in that particular suit for licensing?
But that has been dismissed for default.
Yeah, suit for recovery of possession dismissed for default.
Because there were কোনটা তোমরা আছে এটা এই ম্যাটার আছে but that is a suit for eviction of a licensee that was filed by the Nabu Kumar did not there was a death of Nabu Kumar, substitution was not been made and the suit stands abated. Order copy দিন order copy দিন দুটো দিন abatement যেটা হয়েছিল abatement রেকর্ড করেছে ওই সার্টিফাইড কপিটা দিন না দুটো পাতা দেখা যায় না আমাকে সার্টিফাইড কপি দুটো পাতা দেখা যায় recording abate well may kindly see
You are a plaintiff there.
I was the defendant. I was a defendant in the suit for eviction of a license.
This what is this title suit number 79? Is your suit?
Title suit number 79, yes, my suit. I'm the plaintiff here, but in the suit for eviction of a licensee, I was the defendant.
Hey, first matter tomorrow for dictation. For dictation.
ওগুলো দিয়ে দেবেন দাদা ওগুলো সাক্ষীর কপিগুলো
It has come to me. Assigned হতে পারে কোনোদিন single bench second appeal
item
applications দিয়ে
to 6 since regarding item number 1 to 6 since I have intimated
tomorrow we are keeping it matter 1 to 6 the দিয়ে দাও hearing করে দাও আর এটা dictation দাও
and
the first as to be mentioned first matter
and your lordship I have handed over 2 books before your lordship may I
because one is here I think another one is there. Don't they? You will get it back.